13 of the ban of the volume 1 or volume A. Where we talk about the context. And I want to preface this by saying that everything I'm going to say here is not disputed. The only thing that's disputed, which is not important in what I'm going to say, is that the Zondo Commission did not produce any tangible results. Otherwise, all this is effectively common cause. This is what it says in the affidavit of Dr. Hlophe. If true, these allegations, which include the judiciary for the first time, represent unprecedented levels of real state capture. They exceed by far anything which was previously dealt with in the so-called Zondo Commission on State Capture. That context is crucial in this application. And then he says in the next paragraph, the so-called Zondo Commission, which was dealing with narrower issues, lasted for approximately 4 years. And cost the taxpayer an estimated 1 to 2 billion rand with no tangible benefits. And that's so we can write that off because that's disputed. We'll deal with it later. I'm just doing the introduction. The last sentence is very important. We say, it is largely responsible for the present public fatigue and skepticism about commissions of inquiry and their utility. And I want to start there for a reason. So we all agree that this proposed commission is going to deal with wider issues than the Zondo Commission on State Capture, in the sense explained there. We all agree that that commission lasted for 4 years and cost the taxpayer between 1 and 2 billion. And one can extrapolate that this one will cost at least that or more. And we also all agree that the public is tired or sick and tired of commissions of inquiry and their utility and skeptical about their utility. The reason I'm starting there is because this is the backdrop against which the impugned decisions have been taken. The purported reason, actually the only reason given in the announcement made by the President for placing Minister Mchunu on leave was to make the commission to be more effective, or words to that effect. I'll come to that in detail right now. And a generous interpretation of the leave of absence decision would be that, because we asked the rhetorical question, leave of absence pending what? And supposedly the most generous answer that one could give is that it's pending the commission. So the commission becomes central. Now, we would like to then move on to the issue of, which is going to be central to this matter. That's the issue of the leave of absence. Why is that central? Remember the issue about the interplay between the decisions. So that decision is central in the sense that in relation to the acting minister stroke Cachalia decision, it is purportedly, well, put it this way, there would have been no need to appoint acting minister Cachalia if the leave of absence decision had not had not been taken. Or, to put it differently, had that decision not been taken, then the president would have been free to appoint Professor Cachalia as a minister. That's self-evident. So that's the centrality of that decision. On the other hand, as I've already said, its relationship to the commission is that presumably, my learned friends I'm sure are going to argue this, presumably the leave of absence decision is pending the commission. We will go as far as to say, Justices, that if we are correct that the President, and we are convinced that we are correct on this, does not have the constitutional power to place a minister on leave of absence. If we're correct, for a minute, let's just assume we're correct on that. If we're correct on that, then the question as to whether that decision, once it was taken, was rational or not rational, does not even arise. Because if it's ultra-virus, it's ultra-virus. It doesn't matter whether it's rational or not rational. And if we're correct in that decision, as I say, then the second decision on the appointment of the acting minister also must fall together with it. Now, that is the canvas against which we're going to approach this matter. The next point which I'd like to highlight is that obviously at the back of all this is legality. But we are going to talk about legality in three dimensions. Let me put it that way. And I'll use some shorthand that I know this court is familiar with. So we talk about illegality in the third shore sense. What do I mean by the third shore sense? And I'm paraphrasing. We all know that the third shore decision is a pivotal decision which says that the executive, including the president, or any functionary for that matter, may only exercise powers conferred on them by the Constitution or legislation, or by law. Once you stray outside of what is conferred on you by law, in other words, unlike a human being, you can't just do what you think is right or what looks, you must do that which you are empowered to do. And then there's legality in what we call the Albert sense. And that is the rationality, the standard of rationality, which says that there must be a connection between the means and the ends. And all the cases, pharmaceutical, Albert, and so on. Then there's an area of legality which is probably neglected, which was articulated, I think it's paragraph 3 of the Law Society case, Law Society versus the President, which says that a fatally tainted process renders the decision irrational. And this is what is said in that paragraph. Our president is never at large to exercise power that has not been duly assigned. So that's a rehash of the Fetcher statement. And then Mkhwanazi went on to say, crucially, public power must always be exercised within constitutional bounds and in the best interest of all our people. Always we talk about this rationality in these dry technical terms, but that qualification that for it to be rational, it must also be in the best interest of our people. is often forgotten. And in the context of this case, that raises a few rhetorical questions. Is it in the best interest of our people that we have yet another multi-billion commission which may or may not yield any outcomes? So that, as I will demonstrate, the community and the public can be sanitized and numbed into forgetting. By the time the commission report comes in 3-4 years' time, everyone would have forgotten what the issues are. Is that in the best interest of our people? Is it in the best interest of our people to have 2 ministers holding effectively the same portfolio, being paid over the next 3-4 years, 2 salaries, one sitting at home doing nothing, the other one acting in his place? Can that ever conceivably be in the best interest of our people? And more closer to home, is it in the best interest of the people to have the president doing all these maneuvers of this one is acting, this one is now acting in the place of the one who's acting, to the extent that as we're standing here now, we have 3 ministers of police. One in his absence, in the leave of absence, the other one acting in the place of the acting one. Can that ever conceivably be in the best interest of our people? Is that's what the people want? On top of the already bloated cabinet that is already there. And is it in the best interest to treat the same situations differently? And I'm being generous here. To know, one day, as the decision maker, that you are at large to dismiss a Deputy Minister Whitfield for merely going overseas without permission. Assume that is such a bad thing. But the following day, you don't know that. Suddenly you say, no, I can't. How could I ever dismiss a minister on untested allegations? Is that in the best interest? That a person given so much power as a president, and this court explained in the EFF1 case, the enormous power that is wielded by a president in South Africa, that a person with that much power should be allowed to do that, to amplify that power illegally, as we are going to demonstrate. Now, let me just pause there. I'll come back to the merits. I want to deal very quickly with the preliminary points. In my understanding, well, if judging by the heads and the practice note of the other side, the issue of agency is not contested. Certainly not contested by Minister Mchunu, and it is kind of half-heartedly contested by the President in the papers, and linked to the so-called prematurity point. So the real preliminary point is exclusive jurisdiction. Now, I just want to say this. Again, if you look at the papers, you'll notice that the opposition to exclusive jurisdiction is really, as I say, not so vigorous. But it's very rigorous in the heads for understandable reasons. I would also spend 18 pages on exclusive jurisdiction if I had a case like the other side has. But the issue is very simple. The issue is this: what are the president-specific or so-called agent-specific obligations that are at play in this matter. And I want to say this up front. The fact that those agent-specific and president-specific obligations might be mixed up with other general obligations is neither here nor there. Because I'll be the first one to accept, for example, that the obligations that are in Section 96 of the Constitution are not only assigned to the President, but to all members of the Cabinet, including the President. But the test is simply that we're talking about the Chapter 5 obligations. Nobody in their right mind can debate the fact that to the extent that there are obligations in Chapter 5, those are President-specific obligations, because after all, that chapter is called the President, or at least the first parts, and to the extent that he appoints the Cabinet, that must be read within the context of Section 85. 85.1 says that all the executive power is vested on the President. And then, of course, he has the right to get assistance, to put it colloquially. Now, here's the fallacy of the argument on jurisdiction from the other side. They seek to read too much into the fact that some of those obligations are coupled with discretionary powers. But I'll demonstrate that that's completely, that's really just gilding the lily. The issue is this, and I'll just take one example. So the power says you may dismiss. No, let me take the Section 98 example. The power there says you may, and I'm paraphrasing, you may appoint a cabinet minister to act in the stead of another one. Now, the other side would like us to believe that because that power is expressed as you may assign those powers to the acting, therefore, well, that's the end of it. That means it's a discretionary power. There's no obligation or duty. But that's fallacious logic. Our courts have said many times that you may have a discretionary power, but within it embeds duties. Let me explain that using the same Section 98. So it might be discretionary to appoint an acting minister or not. In other words, you may decide not to appoint an acting minister. But once you have taken that decision, then you have a duty to appoint a cabinet minister. All right? So you can't be mesmerized by the fact that there's a word may in that sentence. Because once you've now chosen that, and the example I was giving to my juniors was, well, I have an option to go on holiday overseas or in South Africa. But once I've decided to make the decision to go overseas, then I must have a passport. I now have a duty. So the fact that the first decision was optional does not negate the duty that is embedded. Now, once that is understood, then the entire attack on exclusive jurisdiction must fall away. Because self-evidently, those duties are on the President, let alone the fact that they are now coupled with Section 83B duties, which are clearly the presidential powers. Let alone the fact that they are also traced on the presidential oath of office. And I'm sure my learned friends, whatever they're going to say, they're not going to say that the duties that arise from the presidential oath of office are not specifically assigned to the president, only as an agent. So that should be the end of that. This case, with the greatest respect, is even stronger on the issue of exclusive jurisdiction than EFF 1. Because you'll remember in FF1, there was a Section 83 obligation to anchor, but it was then coupled with, I think, Section 182, which was the power or rather the duty to obey remedial action. So in a way, you had two weak rights combining to give exclusive jurisdiction. Here you have two strong rights emanating from 83, rights emanating from 92, rights emanating from 98, rather duties or obligations from 98, and also from the oath of office. If we're wrong about that, then clearly this is a case that cries out for direct access, because nobody in this country is going to be able sustainably to say that this is a matter which must, traverse the entire distance to the High Court and to the Supreme Court of Appeal, and one day in 5 years' time come here. That, again, my learned friends are not going to suggest that. Let alone the cynical problem in that proposition, which is that not only must the public be paying for another 3 or 5 years 2 salaries for 2 ministers, but it must also pay for litigation in the High Court, in the SCA, and so on, just for the matter to be resolved. That's only an insensitive person can suggest that is what should happen. So before my free time is gone, I want to go back to the issues on the merits, and I'm going to, as crisply as possible, just outline on each topic what we say are the constitutional problems. Topic 1 is the leave of absence. As far as the leave of absence is concerned, justices, we say the following. As I've already said, the president does not have the power to place a minister on leave of absence, full stop. All the parties, fortunately, agree that there is no such express power, that nobody has to go there. So the best case for the other side would be to rely on some kind of implied power, because we all agree that it's not there. If it was, we would all see it. And we will demonstrate that on the test put by this case, rather by this court with respect, in Amabungane by Nhlanhla J, and as complemented in Mncwabe by Majid J. On that test, which in any event is an accepted test, the test of necessity, you cannot have an implied power unless that power is necessary to exercise the one that is primary. That's just as simple as that. Sorry. If I may, just express that proposition. Hoekstra, in the latest book on admin law, expresses the test of necessity beautifully as follows. Starts by re-expressing feature. It's consonant with the principle that repositories of power can only exercise such power as has been conferred on them by law. Implied powers may, however, be ancillary to the express power or exist as a necessary, and that's where the test is, or reasonable consequence of the express power. And this is the beautiful example she gives. Just as the power to make omelets must necessarily include a power to break eggs, so the power to build a dam may include the power to expropriate property or to remove silt. And then she makes other examples. In other words, for an implied power to arise, it must be a necessary concomitant of the primary power, the one that has been expressed. So how do we bring that home here? You would have to find a formulation, absurd as this might sound, that says that the power to dismiss, for the power to dismiss to exist, it is necessary in the legal sense that you must also have the power to place a minister on leave of absence. Ha.
The clock is, there's the clock, Mr.
Thank you.
Thank you.
Well, yeah, it seems like your clock moves faster than mine.
You'll have to take it for
Yes.
that one.
Thank
Mr. Mpofu, let's just deal with the last point.
This point on
One that
implied
I
powers.
think-
Yes. Thanks, Justice.
You rely on the Masitla principle. I'd like to take you, I'd like to take you to the Masitla.
Masitla. Okay, yes.
Para 68 of
Right.
Masitla, where the court says the power dismiss is necessary in order to exercise their power to appoint.
Yes.
And then at the end, it says there is no doubt that the power to appoint under that section, which is 2092 of the Constitution, and the power under ISA implies the power to dismiss.
Yes.
And somewhere there, it then says that there will be other ancillary powers. You don't just get to dismissal, you may do other things. So in this case, are you saying the president does not have any right to do anything other than dismissing? He cannot suspend a minister or place him on leave? And if so, why?
Yes, thank you. There are about 3 or 4 reasons, but let me move through them very quickly. The first one is that the Masatla case, although it's applicable, is distinguishable in the following sense, that Masatla, as we know, was an employee in the end. And that, by the way, lies at the heart of where the problem is, because the other side treats this situation as if it's an employment situation, which it is not. But that's not even the biggest problem. The relevance of Masatla to this case is peripheral, and I'll explain why. It's relevant in the sense that it gives us the theoretical understanding of implied powers, and everyone has applied it, and so that's not controversial. But if you look at the 2 powers that were in contention in Masatla, which were the power to appoint and the power to dismiss, we don't need that in this case, because in section 92, those powers are expressed, both of them. It says, section 92 says the president appoints and may dismiss. So we don't need Masatla. The proposition in Masatla is actually incorporated in section 92. But if you want to apply Masatla to this case, you have to go further and say that the power to dismiss implies the power to place on special leave. And what I was saying when the clock went is that that proposition can only hold true if the power to place on special leave is necessary for the execution of the power to dismiss. And that is surely that cannot be the case on the test in both Amabungane and Mwabe. So the Masatla principle we accept. And, but we're saying that on the issues before this court, the power A cannot be, or power B cannot be implied from power A, the powers that we're dealing with here, not the power to appoint and dismiss. Yeah. So that's the second answer. In other words, Justice Nhlanhla, okay, maybe let me make it even sound show that the two things are not related. So one of the issues we make, for example, is that by the way, there's no such thing as placing a person on leave of absence. So you can't have a power to do something that's just senseless. Leave of absence, by definition, is something that you ask for. It's not something that can be imposed on you. Right? So, leave of absence is something that is granted. So, that power to grant, or rather, the power to place someone on leave of absence is non-existent on its own right, without it even being linked to the power to dismiss. But in this particular case, the hurdle that the other side has to pass really is the hurdle of necessity. Now, here's the test, the issue, Justice Nhlanhla. In which world can we say that it is necessary for you to exercise the prerogative power, which we know is wide, and you don't need reasons. You can literally remove a minister and just say, and if they say, what have I done wrong? You say, no, you have not done anything wrong. I'm just removing you.
Now tell me, Mr. Mpofu,
Yes.
on that point, is there anything wrong if a president, because what you're saying is, and accept that there's a difference between an employee who would be subject to labor law
Process.
yes, and a politician. Now, if a president decides that out of fairness, he doesn't want to just dismiss a person, wants to give a person an opportunity to respond,
Yes.
is there anything wrong with that?
No, there's nothing wrong. It's just illegal. You can't just somewhere say, okay, for this one, because he's my friend, I'm going to give them a hearing. When I know that, and that's why it goes back to this necessity, I know that it is not necessary to do so. For that question, Justice Nhlanhla, is pregnant with the admission that it is not necessary. It's just, nice to do. That's not the test. The test is that it must be something that is necessary. How can it be necessary to give due process to a person that you can willy-nilly dispose of? We're not talking about kindness here and all those things. We're talking about constitutional obligations. So so there's no rational link between making that decision and the power, because the power is vast, it's big, it's prerogative. It comes from the royal prerogative. That's where it comes from. The royal prerogative was this notion that the queen or the king is only second to God. They can do no wrong. We know that in constitutional terms, that notion has been attenuated, but it is still a wide power of prerogative power. So one cannot just say, is there anything wrong, in the general sense? Well, I mean, if there's a stipulation, let's say, Justice Implied, that says you must answer, I'm putting charges to you and you must give it to me in 7 days. And out of the kindness of my heart, I say, I'm giving you 30 days. I can't say it's wrong. But is it necessary? No. Sorry, Justice. Yeah, it looks like you wanted to follow up.
Well, I'm carrying on with my questions.
Yes. Yes. No. Okay. No. The only point I want to make here is that if as we strongly contend, the the implied power reliance, which is based on the test of necessity, if we are correct on that, then that's the end of it, as far as the legality is concerned. But if we are wrong, then we say that the rationality of that decision is not there. And I've already said the first reason why. It's because there's no rational connection between the two. The second reason was the other one I mentioned earlier, which is that in any event, you can't place somebody on so no law, no constitution in the world can empower you to do something that is illogical, such as placing forcing someone to do something that they should be asking you for. That just should be self-evident. So that's on that point. That's
okay. On the next point is on the appointment of the professor.
Yes.
Acting minister.
Yes.
Let's just unpack that. There's this argument on behalf of the first respondent that the challenge is premature.
Yes.
Because in terms of Section 101, any decision by the president must be in writing. And that has not yet been. He made the announcement on the 13th of July. But the actual appointment, from my understanding, it's still yet to be made.
Yeah.
If you can just deal with
me, yes.
And also address, my understanding of the section is that only a cabinet minister may be appointed as an acting minister.
Correct.
Now, in this case, what do we have?
Yes, thank you. With respect, Justice Nhlanhla, I'm not going to spend a lot of time on this because, with the greatest respect to my learned friends, this is, I don't understand what the defense is here. So, quite frankly, there's no defense. But to the extent that it is attempted, I'll use your questions. And the reason why I say there's no defense is because, my learned friends, we point out in our papers that, as you correctly say in your second question, you can't. That's why I was saying you have a duty. Once you've made the decision to have an acting minister, then you have a duty, according to Section 98, to put a cabinet minister. The president, in his public announcement, said that he is exercising his powers in terms of Section 93. 91(3)(c). That alone should tell you that there's a lot wrong with this picture. He doesn't even mention Section 98. Only in the answering affidavit, when they deal with that topic, what is the first paragraph? They talk about Section 98. So it's an afterthought. What that shows is that when the decision was being made, he was doing it under Section 91(3)(c), which we all agree entitles him to appoint a minister, or rather a minister who's an outsider, quote unquote. In other words, not a member of the National Assembly. Nobody is quibbling with that. The problem with this president is he literally wants to do what is called, you want to have your cake and eat it too. So he wants to appoint Professor Cachalia, but he wants to save Minister Mchunu and not dismiss him. Rightly or wrongly, and I'm not even there. That's really, this whole maneuver is about that. How do I save my friend and close political ally, give him a salary for the next 3 years, 5 years, God knows for how long, while he's doing nothing, but keeps the bodyguards, the drivers, and all those things, and the title, but at the same time, I have someone who must look after the police. So then you think of this long, elaborate contrivance. But the law is very clear. You must do one or the other. If you want Professor Cachalia, then you must dismiss Professor Professor, yeah, maybe, maybe that's where he should be, not in the academia. So it's very easy, Justice Plank. It's very easy. You want Professor Cachalia, then you must dismiss Minister Mchunu. Conversely, if you look at it through the eyes of Section 98, you want someone to act in the place of Minister Mchunu, then you must get someone from the cabinet. It's really simple. And surely, one of the purposes of the constitutional drafters was to save the money of the long-suffering taxpayer, so that when there's an acting minister, you take from the existing ministers. So nobody else, they don't have to be sworn in again. They don't have to get another salary. They don't have to get another bodyguard and all the things that go with it. That surely must have been the purpose of that section. But no, you want to breach it and get somebody else who's going to have their own bodyguards, their own salary, and so on and so on. So the president is very simple. He must choose. He can't have it both ways. You can't breach 91.3c by, or rather abuse 91.3c by all these gymnastics that we see now, of saying, no, he's not really acting, but he's a minister, and I don't even know how to explain the kinds of things that are written here. Because you don't need those gymnastics. It's very simple. You have a right to get anybody, a professor or an accountant or whatever you like, but you must only do that when you are appointing the yes. So that, with the greatest respect, that is that case is non-existent on the other side.
My last question for now, Mr. Mpofu. Could he have maybe, in order to comply with Section 91.3c,
yes,
when he was making the appointment, the announcement said, I'm appointing Professor Cachalia as a minister, and I'm allowed in terms of Section 91.3c to appoint someone from outside as a minister. And then later on, after Professor Cachalia has been appointed as a minister, he is now a member of cabinet, then appoint him as an acting minister, as
an acting minister
of
police.
Of
I get
police.
the question.
Yes.
No. You see, that would be another contrivance. Because remember, Section 92.1 says that the president appoints deputy, 91.2, sorry, appoints deputy and president and ministers, assigns their powers and functions, and may dismiss them. Let's put aside the issue of dismissing for now. So you can't have what in Britain is called minister without portfolio. We don't have that regime because of that section. And in the course of the gymnastics, this was tried in the public domain, but it was soon abandoned wisely. Because when they were trying to backpedal now and try and stop the obvious problem, fortunately, it was abandoned. Well, not exactly. There's some undercurrent in these papers where they try to sneak it, but not boldly enough, because it would be illegal. But, Justice, let me go back to your first question. The first question that you asked is, again, and I say this genuinely, I'm disappointed that the president can try and do this, really, or any president. The president told this nation the following. I'm reading from page 39. In order for the commission to execute its functions effectively, I have decided to put Minister Senzo Mchunu on leave of absence with immediate effect. Then he says, I have decided to appoint Professor Firoz Cachalia as acting Minister of Police. What is so difficult about that? It's a simpler, I have decided. In English grammar, it's called the past perfect sense. Okay? I have decided. It's not I'm going to decide, or I have decided to appoint him as acting minister, not as minister, and that goes to your second question, Justice Nhlanhla. As acting Minister of Police. It's as clear as mud. So you can't backpedal when the problems have now been shown up. You start now coming with all these things that we hear. And if you think that's nitpicking, look at this. He then says, I am appointing Professor Cachalia in terms of Section 91(3)(c). Okay? So again, it's very clear. That one is called the continuous present tense. Okay? And then, just so that we know that he is not, his grammar is not a problem of grammar. He says in the next paragraph, I will appoint an acting minister from within the cabinet until Professor Cachalia takes up his post at the beginning of August. That one is called the future tense. So that means he knows that he will appoint Minister. Now, where are we now, Justice Nhlanhla? We're in a situation where he has already done the appointment of Minister Mantashe. So for you to believe the kind of obfuscation that is being given here, you must believe that the decision that he said he will do has come before the one that he says he has already decided. And what is that? And so it's really just really insulting the intelligence of South Africans, because you don't call South Africans on a Sunday to listen to you and tell them this, and then you try and do the kinds of shenanigans that we have here. So, and in Mncwabe, Justice Majid also dealt with this issue about the public announcement. In a nutshell, what is said in the Mncwabe case is that the decision, once the public announcement is made, that's when the decision is finalized. And here we know that the public announcement has been made. So there is no way. That sentence is where the problem is. I have decided to appoint Professor Firoz Cachalia as acting minister. That goes to your question, Justice Nhlanhla. Because if he had just said, I've decided to appoint Cachalia as minister, there would have been nothing wrong. But if he does that, then what does he do about his friend? He has to make sure that Minister Mchunu gets his salary and bodyguards. And that's why the whole obfuscation and myopia that you see here, and constitutional breaches. So that's the second decision. As I say, we don't need to spend time. That one is self-evidently just illegal, irrational, not empowered, ultra-virus, whatever and not in the interest of our people. So it covers it ticks all the boxes.
Mr. Mpofu, let me allow my colleagues to ask questions.
Okay, thank you, Justice Nhlanhla.
Justice Chiku.
Mr. Mpofu?
Yes, Justice.
You were reading from announcement from the President.
Correct.
And he does say that he is appointing Professor Cachalia in terms of Section 91(3)(c).
Correct.
You don't have a problem with that because he can.
No, I do. I do. You can't do that. You can't appoint someone in terms of 91(3)(c) as acting minister. That's why the thing doesn't make sense.
Well, there are different sentences. I thought that you said that was in the future tense.
No. Okay.
What is in the future tense?
No, what is in the future tense is Gwede Mantashe's appointment, Minister Gwede Mantashe's appointment.
Appointment.
Yes.
Okay, all right. So he said he's appointing him in terms of section 91(3).
C, yes.
C. And does he say, I'm appointing him as an acting minister in terms of section 91(3)?
Yes, that's what he's saying, Justice Chick.
Can
Let's say
can
it says
you read it?
one,
Can
two.
you read it?
Oh, sorry. Okay.
Please read it for me.
Yes. Okay. Sentence 1, 2, 3, 4, 5.
Yeah.
Start with that one.
Yes.
I have decided to appoint Professor Firoz Cachalia as acting Minister of Police. Simple.
Ends there, yes.
Yes.
And then the
Next,
reference,
yes.
then the reference to section 91(3).
Yes, but then he says, in the same breath, I am appointing
Not
Professor
in the
Cachalia in terms of section 91(3)(c) of the Constitution, which empowers the President to select no more than 2 ministers, not acting ministers, from outside the National Assembly. In
Yes,
other words,
I want us to take it step by step because the
Yes.
reference to 91(3),
yes,
he doesn't say as an acting minister in terms of section 91(3). So that one is a standalone sentence that is appointing him in terms of section 91(3)(c).
outside of what he just said a minute ago.
Yes, no. I understand. I'm saying there are 2 sentences. Where I'm getting to, Mr. Mpofu, once he's appointed him, I'm saying he's got a right to appoint a minister
Yes,
in terms
absolutely.
of section 91(3).
Yes,
And he appointed Mr. Cachalia in terms of that section. That's what he says. And your problem is that he appointed him as an acting minister.
not, yes, that's his problem. It's the President's problem.
Okay, that's your complaint.
Yes,
Okay. That is your complaint.
correct.
That's fine.
Yes, that's my
complaint.
Correct.
Now, where I'm getting to is, once Professor Cachalia is appointed in terms of 91(3), does he not form part of the cabinet?
No, Justice Chick, with the greatest respect,
No. I'm trying to unpack this thing for you, with
Yes.
you, so that
If,
now,
uh,
when I come out of here, my thinking is very
yes, no, I understand.
So this is why I was saying, let's separate these 2 sentences. And I'm asking now, and I'm not telling you, I'm asking
Yes,
whether when he then gets appointed, he becomes part of the cabinet or not.
if you mean.
If he is appointed,
Yes.
I'm asking if he becomes
Yes.
a member of
Yes.
the cabinet.
If, in other words, Justice Chick, well, let me put it like this, just so that it's out there and I get it out of my chest. As I said earlier, this announcement must be seen as a package. You can't isolate pick and choose and cherry pick the parts that you like outside of the.
That would be inappropriate. That
No,
would
I'm
be
going to answer the
inappropriate.
question. I'm prefacing the answer. I'm saying the announcement is the announcement. That's the conduct. So it's inseparable. Once the egg is scrambled, you can't unscramble it. But let's come to directly to your question. Of course, and I've said this in my address when I was on the uninterrupted time. We would be foolhardy if we came here. If the president said, I have decided to appoint Professor Cachalia in terms of 91(3)(c), which empowers me to select no more than 2 ministers from outside of the National Assembly, what would we be doing here? Nothing. Because he is empowered to do that. I've already said that. The problem, or the complaint as you put it, that I have, is that he says that in the next sentence, after having said he's appointing him as an acting minister, and the only reason he says he's appointing him as an acting minister is because there's the ghost of Mkhwanazi, which is not going to die, which is sitting there.
I actually don't want us to go there.
Well,
You know,
that's what it is.
Because I'm trying to look at this without involving the politics around it.
No, it's
It is
not
a
politics. It's
I'm
Mkhwanazi.
saying, I'm saying, let's get to it step by step and focus on actually understanding you know, because you've got a problem with the term acting. And I'm not going to ask you what the president has said about the fact that acting is just there as an acting. So what I was asking you to help me with is whether after his appointment, he becomes a cabinet minister or not.
That's the question.
Yes.
Yes. Anybody who's appointed in terms of Section 91 becomes a minister after appointment, whether they come from the National Assembly or come from wherever. They become a minister, yes.
So once he has become a minister, then the president, and the reason, if you can just be patient with me, you know that there are certain ministers, for instance, who are ministers in the presidency. You've said that in our country there are no ministers without portfolio, but you do know that there are ministers in the presidency. I'm just making an example of that. Once he has been appointed as a minister and he is part of the cabinet, is there anything preventing the minister then from then saying, okay, you are an acting minister?
Ooh. If there was something wrong with that, Justice Chiku would be attacking the appointment of Minister Mantashe. How can there be anything wrong with appointing a minister as acting? That's what Section 98 says.
So what we are attacking, the complaint is the fact that the minister in his press release, the president in his press release said that I'm appointing Professor Cachalia as an acting minister. The use of the word acting when he was making the press release.
No. It's not about the press release. Go to page 91 of the President's affidavit. Paragraph 57.
It's in page?
91, Justice. Paragraph 57, the President says, long after the announcement, last week, I have outlined the above reasons why, given the nature of seriousness of the allegations against Minister Mchunu, which that's what it is, it's not politics. I have elected to appoint an acting minister of police from outside cabinet, as I'm entitled to do in terms of Section 91(3)(c). That is wrong. There's no such, that sentence, which is not in any announcement, is constitutionally confused. I've elected to appoint an acting minister of police from outside of cabinet. You can't do that.
Okay, all right, Mr. Booth. Thanks about those responses. Even though I can read from your body language, you are irritated with me.
No, I'm not.
Can you both take a deep breath?
I'm very happy with you, Justice Chick.
Can you both take a deep breath and proceed?
No. Okay. No, I'm not. I really am not. Maybe I'm just not looking as I should. But on a more serious note, Justice Chick, I get what you say, and that is why I said in my address, this thing would have been if one didn't want to do these machinations, which you call politics, then this thing would be very simple, because the president would have done exactly what you're saying. He would have simply said, "I've looked at this thing." He had two choices, by the way, because our learned friends keep on saying, "Well, they're goading us. Yeah, why are you saying he must dismiss him? He must dismiss him." Forget about dismissing. He had a choice to retain him. He could have said, "I don't care what Mkhwanazi is saying. I'm retaining him." But once you decide to retain him, then obviously you then can't have someone acting in his place. Or he could have dismissed him. And had he dismissed him, then what you're saying would apply. It would have been...
Let's move to another point.
Yes.
Perhaps this will also need some kind of a patience so that you can explain this to me.
Yes.
I'm looking at the Constitution concerning exclusive jurisdiction.
Right.
And in my thinking, I'm saying the complaint concerns the exercise of a power and how the president has exercised the power. And yet the Constitution talks about failure to fulfill a constitutional duty. So what's this constitutional duty that he has failed?
Okay.
Because I thought that the complaint is that he established a commission of inquiry and he put Minister Mchunu on special leave, and you disagree with that. You disagree with the fact that he adopted that approach. You disagree with the fact that he appointed a commission of inquiry. And then the third one was the appointment of Professor Cachalia as an acting, as an acting minister instead of just being a minister. So now I'm grappling with what is the constitutional duty that has failed.
All right.
To
Thank you.
fulfill.
Thank you, Justice Chick. Okay. What was said in the EFF1 case, and my vote counts, and all the other cases, is that the failure, and that's in any event a reflection of 167 4E. Once the complaint is the failure of the, remember, sorry, I'm sorry to do this, but let's start from the beginning. According to Gaba, this court said, when you are looking at jurisdiction, you look at the pleadings, what is alleged. Whether we're going to win or not, that's a different matter. But what has been pleaded, okay? So what has been pleaded in this case is that in doing all these things, and I'm not going to count all of them, the president failed to uphold the Constitution in terms of Section 83B, okay? Now we know from EFF1 that that is not enough, because otherwise it would mean every time the president does something, you say he failed to do, to uphold the Constitution and so on. So there are, what shall we call it, limiting mechanisms which say that that broad power in 83 must be coupled with a specific, agent-specific presidential power, right? What, therefore, are the agent-specific powers that are at play here? I've already made the example again when I was doing my introduction, that just let's take the discussion that you and I were having. Once the president decides to have an acting minister, as it says here, then he has a duty, a constitutional obligation to ensure that that person is a cabinet minister, right? An existing cabinet minister. So that's one. Two, I'm just using that as an example. There are many other, I could use 91(2) as well. Yeah. But let me jump to what I call the constitutional, or rather, the oath of office. In his oath of office, which obviously only accrues to him, he has undertaken to follow the prescripts of the law to the best of his conscience, not to favor his friends, as we have alleged, rightly or wrongly. But we have alleged that this is motivated by his personal affinities with Mchunu. We've alleged it. Are we going to prove it? I don't know. But we have alleged it, and that is a breach, at least a prima facie breach of his obligations to exercise his conscience and not do strange things like that.
Okay.
So,
Let's move to something else.
Yes.
Because my colleagues, I'm sure they are very eager to ask their own questions.
I don't think so.
Are you still proceeding, continuing with the challenge against the establishment of the
Yes,
Commission of
thank you.
Inquiry?
Yeah, in fact, thank you, Justice Chico, for asking that.
The reason I'm asking that, other than the fact that you haven't had the opportunity to deal
Yes.
with it, is that I think I saw somewhere in your, I think it was in reply, where you said that Mr. Mchunu's defense or something to that nature would best well be dealt with in the Commission of Inquiry.
No.
And maybe and it gave me an impression that you actually now probably thinking that perhaps the Commission of Inquiry is not such a bad idea.
No. That's what they say in their papers. They are completely wrong in their heads. Let me explain why. Well, let me start with your very last few words so that it's clear to everyone. Standing here, we do not say that the president does not have the power to appoint commissions of inquiry. Nor do we say, although with all the quibbles about the taxpayers and so on, as covered in the article that we submitted yesterday by Michael Bishop. Nor are we saying that the commissions per se, forever amen, are a wrong mechanism. Because there are some redeeming features about commissions. It has been said correctly, I know this from personal experience, that they can also be accountability mechanisms. In other words, assuage the public's right to know and so on. No, that's not where we are. Let me tell you what our case is, not the one that they want to answer, which we didn't plead. Our case is as follows. Two things. One, we say on the specific facts of this case, the president had no, let me put it this way, it was irrational for the president to appoint a judicial commission of inquiry. Okay? Now, there's a difference between a judicial commission of inquiry and a commission of inquiry per se. Section 84(2).
Mr. Ofu, I'm sorry, I'm now conscious of the fact that
Yes.
we've been debating quite
Yes.
quite a long time. So I want to be fair to my colleagues. You do know that the president is saying that there are different stakeholders that have been implicated here. It's not just the judiciary. It's
So do we.
SABC and
Correctional services,
Correctional
police.
Exactly. And when I was thinking about it, I was thinking that, for instance, I think that in your heads you made mention of an alternative that could have been pursued was JSC and Magistrates Commission.
No. That's a different.
That was not you.
No, it was me, but that's it's unrelated to what we're debating. I'm coming to the JSC point. Let me explain, Justice Chick, if I may. Yeah. What the JSC point is a different one about usurping the powers of the JSC. I'll come to that.
No, I'm actually not on that point as well. I'm simply saying, as an alternative, I didn't think that the JSC and the Magistrates Commission would be the suitable.
No, you never said that.
You never said they could be the suitable option.
No.
Okay, all right.
Okay.
Continue.
So this is what we are saying. We are saying that, Justice Chico, let me make this graphic for you. We say on the facts of this case, for the first time in South Africa, a Lieutenant General says that after police investigations, they have found that the judiciary is involved in crime and corruption and all the things, the sordid things that Justice Mkhwanazi.
And the President's take on that is that it's highly unlikely that they would implicate judges of this court because criminal cases starts at the magistrates' court at a lower level and then perhaps the high courts.
No.
And then he says that when he decided to speak to the Chief Justice, he had this in mind that at least this court would not have been dealing with matters pertaining to criminal investigations and all of that.
Firstly, the president never said that. That when he spoke to the Chief Justice, he had in mind that, he said
What
he
does
spoke
he
to the
say?
Chief Justice about the identification of the judge. So he never said that. Let's be fair to him. Yeah.
In his heads of arguments, what does he say?
No, he says the following, which is an afterthought. It's what we call ex post facto rationalization. He now says that in any event, Justice Nhlanhla would be untainted by the accusation, by the Mkhwanazi accusations, because of what you've just said. Because criminal cases start in the magistrate. But so what? Criminal cases also come here.
But Mr. Mpofu, you know, you separating what he said in the affidavit and in his heads and all of that, it just gives me problems because I'm trying to summarize what his version is.
Well, I'm afraid, Justice Chick, if I'm not allowed to correct what you are saying.
No, you
the
are
president
allowed.
did not say that he.
You are allowed.
Yeah, he never, I can assure you now, I've read these papers 1,000 times. The president of South Africa has never said that when he spoke to the Chief Justice, he did so because of that other thing that he says about the Constitutional Court cases. He never said that, to be fair to the president. So I was simply trying to explain that. If it's here, someone else will show it to me. But it is not here. The president says two things. He says, in identifying the judge, so I spoke to the Chief Justice to ensure what he calls the legitimacy and gravity of the commission, and therefore we agreed on the acting Deputy Chief Justice. He says that. In a different place, when he's now talking about the fact that Lieutenant General Mkhwanazi implicated the judiciary, he then says, well, in any event, I am of the view, I'm reliably informed, something like that, that the Constitutional Court judges could not be covered in the he says, this is at page 81. There is no suggestion by Lieutenant General Mkhwanazi of any impropriety at the level of the justices of the Constitutional Court. The allegations implicating members of the judiciary pertain to criminal proceedings. Where he gets that is I don't even know where he gets that. And then here's the part. As far as I have been able to ascertain, that's the expression I was looking for. As far as I have been able to ascertain, none of the proceedings to which the allegations relate was ever referred to the Constitutional Court for adjudication. Well, this statement is fraught with illogicality. Firstly,
but who is saying this, Mr.?
It's the President of South Africa.
Yes, and when I was engaging you, I was summarizing what was in the founding affidavit and what is in the heads. And I'm talking about a version here, and I'm not quoting verbatim.
Okay, thank you. Yeah, you are right, Justice Chick. But the point I'm making is this. Let's look at it. Let's look at it on its terms. Let's look at it on its terms. Not worry about whether it was linked to the Chief Justice or not. Let's forget about that. Let's look at it now on its terms at paragraph 27. I'm saying this thing is fraught. It's fraught. Sorry. It's fraught with illogicality, Justice Chick, as follows. You can't come for the first time in your answering affidavit and say that there's no suggestion in Lieutenant General Mkhwanazi of any impropriety at the level of the justices of the Constitutional Court. Where does that come from? Justice Nhlanhla, who's part of the judiciary, all Lieutenant General Mkhwanazi said was he never said judges in the magistrate court, in the high court, in the SCA, in what, he said the judiciary as an institution is implicated in drug dealing, in the cartels, in the money laundering or whatever the things. Now, let me say this very clear. I am sitting here, now I'm speaking for myself. I do not believe that those allegations, cover the entire judiciary at West. It would be ridiculous. But that's not the point. The point is this, Justice Chick. The institution, and the President uses that word, by the way, in his announcement, or rather in the terms of reference. The institutions that have been accused include the judiciary. Now picture this, Justice Chick, in your own mind. We are in a court of law. Complainant is Lieutenant General Mkhwanazi. And he says, the accused are the Metro Police, the Judiciary, the correctional services, politicians, and so on. They're lining up here. And you then say, one of the accused must go and be the judge. Oh, sorry.
Okay.
You look like an accused.
For now, let me allow my colleagues. Let me allow my other colleagues to pose their questions. If there's a burning question, I feel
yes.
I need to ask you.
Maybe then, Justice Chick.
I'll ask that.
Yes, thank you. Can I just take advantage of the fact that we touched on the JSC thing so that I just complete that point? Yes. So the point about the Nemo Judex, which is an obvious principle of our law, that you can't be the judge in your own way, you can't be an accused and can't be a referee and a player, as people would say in the street. It's a simple concept of law. So that's the first thing. But we then go further and we say that in any event, even if this was not even if this was a non-judicial commission, so to speak, and we know we've had those. We had the TRC had a bishop as a chair. The Muarane Commission had an advocate as a chair, and so on. So there's nothing that compels the president to have a judge. But we say even if this was we say even if this was a non-judicial commission, it would be problematic for a second reason, which is that you would be imbuing that commission. Let's, for argument's sake, call it now the Muarane Commission, not the Nhlanhla Commission. You would be imbuing that commission with the power to investigate the conduct of judges. Okay? That function is constitutionally and exclusively preserved for the JSC. So you cannot usurp the powers for all the reasons that we know, to preserve the independence of the judiciary and so on and so on. You can't now have a new entity called the Nhlanhla Commission or the Muarane Commission or whatever commission for that matter, or the My Nature Commission. You can't have that commission investigating the conduct of judges, because there are constitutional reasons why that function is specifically preserved for the JSC or the Magistrates Commission. So that's a second reason, assuming we're wrong about the first one of Nemo Judex. But those two, so please, nobody must say we're saying there should be no commission. We might think it, or the public might think it, but we're saying that in this part, on these facts, a judicial commission, when the judiciary is one of the accused, is constitutionally inappropriate. Thank you. Sorry.
Thanks, Mr.
Thank you.
Thanks, Justice Nhlanhla.
Thank you, Justice Nhlanhla. Mr. Mpofu, if the President had said that he's placing Minister Mchunu on suspension with full pay, would the applicants have been able to advance the arguments that that are being advanced on their behalf today?
If he said he was placing him on suspension with full pay, well, at least one of the arguments that we're advancing would not be competent, which is the one about imposition, because a suspension, as we all know, is something that is imposed. But the other arguments
Are
would
we
still.
playing with words in terms of leave of absence and suspension when the one might mean the other? And are we placing form over substance?
No, Justice. You see, the president. Let me, and again, since I was listing disappointments, this is another disappointment, because the president seeks to mislead the court by creating, to justify that by pointing to the Zweli Mkhize example. And he says under oath that he placed.
Mr. Mpofu, I'm very mindful of time. My question is a simple one. Are we placing more emphasis on form over substance? Regardless of what the president may have said, the president may have used the words leave of absence. Are we here in this courtroom now, and we have to distill this matter, are we placing emphasis on form over substance? If we have to say leave of absence is this, it should have been suspension, or if the word suspension had been used, then some arguments would not have been advanced today.
No, we're not, Justice Theron. Firstly, because I've answered you to say that some of those arguments apply to both. So why would it be form over substance? And I'm saying the one argument which would not be competent, which I concede would not be competent, is the one about the imposition. I'm isolating it to that, but I'm not, that doesn't mean all the other...
Would the president, or does the president have the power to suspend a minister?
No.
And what do you advance as authority for that submission?
Because it goes back to where we started. That power can only, since we all agree, all of us in the room agree that there's no express power, that can only be found on implied powers. Okay? So there are two reasons. When the Constitution wants to, when the Constitution wants to afford the president the power of suspension, it says so. It says so in section 177(3), I think. Yes. So section 177(3) says, the president, on the advice of the JSC, may suspend a judge who is the subject of a procedure in terms of subsection 1. So that's the power to suspend. It also says so in section 194(3)(a). Section 194(3)(a) says the president may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. That's to do with Chapter 9 institutions. So we don't have to be scratching to find a power to suspend where it does not exist. So if the constitutional drafters wanted to grant the president the power to suspend ministers, it would have said so, as it has done in 177 and in 194. Why is that so? It is because, Justice Theron, let's take the 194(3)(a) situation. In both situations, that suspension is pending an inquiry. Right? So this is Amabungane and Nwabe now, but from the flip side. Why is that suspension pending an inquiry? Because when you are impeaching a Chapter 9 institution holder or a judge, there has to be an inquiry. But when you are removing a minister, there is no need, it is not necessary to have an inquiry. So you can't say, I am suspending you pending an unnecessary inquiry. In the other two examples, you do so, and that is why this court, per JAFTA, in EFF2, made the clear distinction between a motion of no confidence, for example, and impeachment. And it said when it's an impeachment, because of its punitive characteristics, you have to have an inquiry. But if you are going to be removed as a result of a motion of no confidence, you don't need any inquiry, because that one is a no-fault removal, if you like.
Yes, I was listening quite carefully to your interaction with my sister Justice Chitri when she referred you to EFF1,
Yeah.
and you accepted as what is stated there that where reliance is placed on Section 83 to establish exclusive jurisdiction, the exclusive jurisdiction of this court, it has to be coupled with another express obligation on the part of the
Yeah.
president. And if I understood you correctly, and please correct me if I'm wrong, you said the obligation that it's coupled with is the obligation on the president to exercise his conscience properly and not to favor his friends. Did I understand you correctly when you said
It was one
that's
of the obligations.
Where in the Constitution now do we find that obligation?
Okay. We find that you'll find it in Schedule 2. Section 87 of the Constitution says that before you can be a president, you must take an oath of office. Okay?
I ask you to make your best point now, Mr. Mpofu.
And then in that Schedule 2 oath, one of the things it says, and anyway, Justice Mogoeng made a point about this in FF1, that the president is the only person in this country.
Are you referring to the minority judgment there?
No.
Which one?
Justice Mogoeng, there was only one judgment.
No,
Yeah,
F1.
it was
The
the unanimous judgment. There was no minority. So he made the point that the president is the only person who is required to take the oath in front of all of us. And when he was explaining. So
saying the obligation that the applicants are relying upon is found in the oath of office.
yes, and it's the one.
Not in any section of the Constitution.
Sorry, I don't understand that. The oath is part of the Constitution. It comes from Section 87. Let's go to Section 87.
Specific obligation.
Yeah, Section 87. Okay, Section 87 of the Constitution of South Africa. Which is also in Chapter 5.
Looking for a specific obligation.
Yes.
Mr. Mpofu.
Okay, I won't even preface. I will always discharge my duties with all my strengths and talents to the best of my knowledge and ability and true to the dictates of my conscience. That's what, when I refer to the conscience, I was referring to this, okay? Dictates of my conscience. What does that mean? It means I'm not going to say because it is this one or that one, I'm going to be biased in their favor.
Define the obligation for me, please, Mr. Mpofu.
Act according to the dictates of your conscience is an obligation found in this book. Yes. It is.
Finish my question.
For that,
my question, please.
For that leg, yeah.
Is that the express obligation that the applicants then are relying on? The express obligation that has to be coupled with Section 83. I'm just trying to understand.
It's one of them.
Which is the other?
I said, the other one, I made the example to Justice Chikri. I traced it to Section 98 And I said that once you have decided to appoint an acting minister, once you have exercised that choice, then you have an obligation to ensure that it's a member of the cabinet that is appointed. That's a duty that only one person can.
Is it an obligation or a jurisdictional fact that must exist?
Well, an obligation can be a jurisdictional fact. It's not one or the other. The fact that something
Talking about
is
exclusive jurisdiction.
yes,
Obligations in relation to exclusive jurisdiction.
yes.
Because let me
Sorry.
finish my question, please. If it's a jurisdictional fact, then that doesn't go to exclusive jurisdiction.
Why? Why? If you say, for you as the president to let's say to appoint a director of public prosecutions, that person must have an LLB. That's a jurisdictional fact.
Let me try and make it simpler. In order for this court to have jurisdiction, and where reliance is placed on Section 83, it must be coupled with another express obligation of the president,
Yeah.
not a jurisdictional fact that must exist before the powers in 83 can be used.
No, that's not the law says it must be coupled with another duty, which is president specific and agent specific. And I've just given you two. One.
I've heard you, Mr. Mpuku.
Yes.
Let's move on.
Yes. Okay.
Now, let's go to direct access
Yes.
and urgency.
Agent.
If I understand the applicants, they rely primarily on costs and on expenditure in relation to why direct access to this court is justified. Now, this is my question. If I didn't understand,
No, you
you'll correct me. Does the possible expenditure to be incurred as a result of the decisions of the president which are being impugned meet the standard of exceptional circumstances that this court has held necessary for direct access to be granted?
No, not on its own, obviously. That's not what we are pleading. We are saying that the matter is self-evidently urgent, and nobody seems to have a problem with that. We are saying on top of that, this is a matter of the utmost public importance. I don't think I need to motivate that. And we're saying that the cluster of these decisions is such that they are about to be implemented in 2 days' time. At least the one decision of the appointment of the so-called acting minister. And the other decision, which is the Judicial Commission, which we say is illegal, is already, I think it has already started. There was a press conference yesterday. So so it's not just a question of cost, in that sense. It's a question of saying, is it in the interest of anybody that billions and billions must be spent in what might then be found in 2 or 3 years' time to have been an illegality? Obviously not. Is it in the interest of the country or anybody that there should be an acting minister that we might find in 3 years' time was not properly appointed? Obviously not. And that's why it's urgent, because the implementation in the one case has already started, in the other cases in 48 hours.
In relation to the applicant's claim for direct access, could the applicants have approached the High Court for interim relief in respect of the appointment of the acting minister, or in respect of the commission not starting its work immediately?
No, because the issue about I'm not sure whether we're talking about exclusive jurisdiction or direct access. As far as direct,
Let me make it clear.
yeah,
I'm dealing now with the claim for direct access.
yes, okay.
On the basis that there's no exclusive
Yes,
jurisdiction.
yes.
I'm dealing with the alternative
Yes,
claims
alternative, yeah.
that have been advanced by the applicants
Yes.
for them to approach this.
Yes. Well, then the question that doesn't make sense because whenever you apply for direct access, you can. It doesn't mean you can't because it's not exclusive jurisdiction. So every time you apply for direct access, every time,
Mr. Mpofu,
yes, just,
I'll request that you at least answer the question.
Yes.
If you don't understand, ask it to be understood.
no, I
But
understand.
don't say the question
Okay.
doesn't make sense.
No. I don't mean it in a negative sense. I said that I'm the stupid one here. Yeah. So I'm saying it doesn't make sense to me. Yeah. Because my understanding, Justice Teron, if you took it differently, I'm saying that every time, when you ask for direct access, it does not mean you can't go to the High Court. Because that's a question of exclusive jurisdiction. It means you can go to the High Court, but you are asking this court for direct access for the reasons that we've gone through. So the question that says...
My question is, Mr. Mpofu, why could the applicants not have gone to the High Court?
Okay.
Why could they not have got relief in respect of interim relief, in respect of the appointment of an acting minister and the start of the Judicial Commission?
Yes. Okay. Now I understand the question. Because, one, the matter is of the utmost urgency. Two, it is a matter of public importance. Three, it raises important and novel constitutional questions which would inevitably end up in this court. Now, whether we want to wait for that inevitability in 4 or 5 years' time, or we want to do it now, and four, the matter, and this is common cause, does not involve disputes of fact. So all the parties are clear.
Can you refer me to the papers where the applicants deal with that?
Yes.
Where the applicants say that why, in respect of the claim,
Yes.
direct access, why they can't approach the High Court?
Yes,
Really?
you'll find that on page, and by the way, in the respondents' answering affidavit, there's no response to this. You'll find it on page, sorry, I'm looking at the answering affidavit. 9, thank you. Is it 9? Just relying on my junior. You find it from page 10, paragraph 15. And we've put 4 things there. We say, alternatively, and in the unlikely event of this court finding that its exclusive jurisdiction is not triggered, then the applicants will apply for direct access upon the following grounds and exceptional circumstances. 1, the matter concerns an urgent matter of the utmost public importance. I've already said that. We say the court may take judicial notice of the nationwide peaceful demonstrations concerning the Mkhwanazi revelations. The first respondent himself has repeatedly affirmed the urgency of the matter. 2, we say the matter concerns crisp constitutional issues, that's what I just said, with no need for adjudication of factual disputes. As demonstrated below, the prospects of success are overwhelming. 3, we say the very nature of the matter is such that no useful purpose will be served by taking the matter to the lower courts, which is allowed, as I explained earlier, before its inevitable referral to this court. The continuing depletion of taxpayers' money is also of relevance. And 4, we say in the totality of the circumstances, the pleaded herein, and then that obviously deals with the other facts, it is in the interest of justice that the applicants be granted direct access. In other words...
What do you say about this court's decisions in Zondi, the Tiki Dry, a number of others where this court has said that it's indirect access matters, the views of other courts are especially important?
Yes.
And while we might be dealing with an important constitutional matter, that may actually sway the scales in that important matter first being considered by the High Court and perhaps the HCA for this court as to sit as a final arbiter. So the constitutional importance of the matter may actually work against the applicants, and I don't see that being dealt with in the papers.
Well, it's dealt with in the 15.3. Let me repeat again. We accept that the matter, as I said earlier to Justice, there's nothing stopping that's direct access by implication means that the matter can go to the High Court. But we say that...
For you, just to preface it, it's on the applicant to show why it should be decided by this court.
Yes. Why? Is because if we did that and waited for the matter, what we call the inevitable referral to this court, as I say in 3 or 4 years' time. If we waited for that inevitable arrival of this matter to this court, by then there would be no country left in the sense that you would have had an illegal...
Is that dealt with on the papers?
Yes, Justice. When we say the very nature of the matter, then let me pause there and tell you what the very nature of the matter is.
No, I think
Well,
all judges understand the nature of
Yeah,
the matter.
that's
It wasn't clear to us there'll be no country left as the submission that you made.
Yes. So the nature of the matter, the nature of the revelations, the nature of what we're dealing with here is such that, so when I say the nature, I don't have now in this and then say that nature is ABCD. That nature is in the founding affidavit as it is. So when I'm dealing with direct access, I'm dealing with someone who has read the full affidavit, who knows that we're dealing with implied powers that may not exist. We're dealing with 3 acting ministers and all that. We're dealing with a judiciary that is investigating, that is being investigated by a member of the judiciary. We're dealing with the possible usurpation of JSC powers and all those things. That's what we mean by the nature of the matter.
I have 2 more questions, Mr. Mpofu. The one relates to separation of powers.
Yes,
We look at Section 85.
yes, I have.
Section 85 vests executive authority of the Republic with the President.
Correct.
Now, would it not imperil the separation of powers if this court was to interfere with the President's exercise of his authority?
Yeah. No, it wouldn't. It wouldn't, Justice Teron, because all the cases, including all the cases against the president that were ever brought to this court, have made that point, that the general rule is separation of powers, but the exception to that general rule is the standard of rationality. That's tried. So the fact that the president can, we're not in England where the Queen can do whatever they want. Here we have a constitution. So the president can do whatever he wants, but it must be rational. And who are the determinants of rationality? Judges. So the only place, once you feel that the president has done anything that's irrational, there's only one place where you can go to. It's a court of law. If that court of law is going to say, well, go back to the president, well, then we'll have no country again.
Mr. Mpofu, if the court is not with you on the merits, what are your submissions about costs?
The 2 applicants, at least, well, in short, BioWatch applies.
Now, the applicants, and I think, have made numerous allegations that don't directly relate to the merits in this matter. They refer to the president protecting Minister Mchunu because he's a political ally. They refer to Phala Phala. They refer to State Capture Commission, which don't directly relate to the legal questions in this matter.
In what ways, Justice?
And if they don't directly relate to the legal questions, is the applicant's primary goal political? And should they be spared from costs?
Okay, first let's start with the first leg. I can't fathom why the allegations, which are not denied, by the way, about what we call the factional or political affinities or the historical relationship between the president and Minister Mchunu. Everybody knows that they were the two top of the ticket in the so-called CR17 matter that has come to this court before. So I'm sure this court is familiar with it. Everybody also knows the Pala matter has also come to this court. So everyone knows that that matter is in the public domain, even if it had not come to this court. So if one makes, you can't just, if you wanted to impose costs on the applicant, you would do so if they come and said, no, the president is just biased, without substantiating. But when they substantiate, and you want to punish them for substantiating why they're saying the president is the reason why he is treating Minister Mchunu differently from Deputy Minister Whitfield, is because the one is his political ally, and explain why. If you're going to be punished for that, for substantiating, that it might not be so is a different matter. But to be prohibited by a court from saying it, then again we'll have no country. Because it would mean nobody must say what is, must even allege, let alone anything about this president. They mustn't allege it, let alone having to establish it. Well, that's fine then. Then in that case, yes, the applicants should be punished for expressing a view about why they are saying the president is biased in this particular case. Then they can be punished or face the. Yes. Oh, sorry. And in any event, just it's interesting, but the the president is not asking for costs, let alone punitive costs that are now being suggested. And I'm sure it's because the president understands. In fact, the president has dealt with those issues with the Pala and the.
Mr.
Sorry.
Pofu, nothing has been suggested. Questions are being posed,
Yes,
on
okay,
which we
yes.
would like to hear your view.
Yes. No, I'm saying.
Just
yeah.
to make that clear.
Yes.
But
On those
you've answered my question.
Yes.
Thank
Those-
you very much, Mr. Mpofu.
It's a pleasure.
Justice Nhlanhla.
Mr. Mpofu,
Yes, Justice Metop.
well, it is common cause that this matter is urgent. All the parties agree.
I would have thought so, Justice Metop.
And if it is urgent, it is also common cause that for you to come home, you have to establish whether you have exclusive jurisdiction or direct access.
Yes.
You may be weak on exclusive jurisdiction, but you'd come home on direct access.
That's,
Speaking for myself,
yes.
I think you do come home on direct access
Thank you, Justice Metop.
for the reason that you've expressed.
Thank you, Justice.
I'm just saying it.
Yes.
But my mind is open, I'm keeping an open mind. Your colleagues, prima facie, your colleagues may convince me otherwise.
As God please.
So then there are three issues.
Yes.
It's the issue of
Leave of absence.
whether the president has implied power or not. And you are saying Masetle is against us.
Yes.
Or it's against the respondents.
Yes.
And if it's correct, then the appointments, the second appointment and the third appointment fails.
Absolutely.
In other words, if you don't come home on the first point,
Yes.
is it correct to say the second and the third point you fail?
No. no. It's the other way around, Justice Matopo.
No, but if you,
Thanks for
let me put it this way.
Okay.
If we find that the president has the implied power and the necessity that you said does not exist, right? Then he would have had the power to make the appointment.
Yes, Justice Matopo, thank you for that question. I really appreciate it because I think it gives me an opportunity to explain my case properly. Yes, Justice Matopo, you're right. In fact, the analogy you make works in the one way, but not the other. Let me explain. If we are correct that the president does not have implied power to act, in other words, he acted ultra vires, then there's no need for this court to then examine whether that leave of absence was rational or not, because it's already ultra vires.
That's fine.
I agree, yes. So, however, Justice, the opposite does not hold true. So if the court is against us on implied power, then it means the court has to then look into the question of rationality. In other words, let's assume the president does have the power, but on these facts, did he exercise it rationally? And the answer, the short answer we give is that since there is since he was exercising.
Let's because we've had this long debate.
Yes, we have. Yeah, thank you, Justice.
If he has the power, right? Let's put it this way. You are saying if he doesn't have the power,
that's it.
That's the end of.
Yes.
It's like it's
end of go to rationality.
Falls down. But if he has the implied power, you go to rationality.
Absolutely.
And if we find that the actions or the decisions were rational, you're out as well.
I'm out.
So
completely.
If you're out on everything.
No.
That's where I went to.
No. Okay.
So how can you be in when you're out on the main one?
Okay. Because Justice Matopo, it's the president of this country, it's not me who said he must make 3 decisions. So he made the 3 decisions, and we're assailing them. That's why you have prayer 3.1, 3.2, and 3.3. So we assail them in their individual right. In other words, to answer your question in shorthand, Justice Matopo, it is possible, theoretically, it is possible.
No, let's be practical. Let's not be theoretical. Is it
Shouldn't be fine. Thank you. Checks on it.
On these pleadings, on the rest of the motion, it's possible for the text to say, we're giving you 2.1 but not 2.2, 2.2 but not 2.3. So it's not what those cases where if you don't come right on 2.1, you're out. And the reason for that is because, for example, while the
Your mic is not on, Mr. No power.
I thought it was still not working.
Not working.
Thank you, Justice. No, you're right. I thought everything was out. Okay, but, it's back. So I'm saying, Justice Matopo, pardon? Mine is on, yes. I'm saying that the Judicial Commission decision, for example, can be viewed on its own, it can be impugned, let me put it that way, on its own. In other words, you could say the president has the power. Yeah, has the power, and he exercised it rationally. Yes. On leave of absence, yeah. Then 3.1 is gone. Yes. Yeah. Now I'm saying if you do that, then the Prof. Cachalia decision can be viewed in its own right. So you can say that and still say, but the president did not have the power in terms of Section 98 and 93, the discussion I had with Justice Chikwi, to appoint Professor Cachalia. And, thank you, yes. And you can also say the Nhlanhla Commission. Yeah, thank you. Thank you very much. Thank you. Yes. 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 Yes.
For me, it seems like you place more emphasis on the president, or I will appoint, I decided to appoint. Did I read it correctly?
No, you read me incorrectly. Because that's what Justice Chikwi was accusing me of that as well. And then I took her to page 91 to show that it's...
So it's not?
No, it's not. It's not just the announcement. It's what he says in the answering affidavit, which is the same thing.
So are you saying constitutionally, the president, okay, let's say it's common cause that the president constitutionally, in terms of Section 91(3)(c),
See, yes,
can appoint an outsider
as a minister,
as a minister?
100%.
Right. Now, if we take the facts of this case, if correctly the president has exercised the powers which you are disputing, the implied powers to put Minister Mchunu on leave of absence,
Yes,
he's off. And the president exercises his power in terms of 91(3)(c) to appoint Professor Cachalia. And once he's appointed, he becomes a cabinet minister or a cabinet member,
yes,
right? Professor Cachalia will not assume or take office until he has been sworn in,
sure.
right? We agreed.
We agree.
And according to the president, he will only take office on the 1st of August.
Agreed.
We agreed.
Agreed.
So what will start is the announcement.
The
Right?
appointment.
Sorry, it's the announcement, followed by the appointment in terms of 91, 93, what is the?
91(3)(c).
91(3)(c). No, I meant 90.
8.
The first section where he has got the right to appoint and dismiss,
That's 92(1).
92(1).
Sorry, 91(2). Sorry.
And yeah,
91.
he has to make that appointment, right? Once he's appointed, then the president will look, where do I place you? Where do I place you? And he looked in the position where Minister Mchunu has been put on leave of absence. There is a vacancy, right? And if the president says, because there is a vacancy, you are now a full-time minister, I can, to use the political word, I can deploy you,
Redeploy you.
yeah, or redeploy you to the position of Minister Mchunu. He's absent from work, unable to
Is absent from office. Yeah.
right? Why is that wrong?
No, it's not wrong. It's just not what happened here. The president should have come to you before what you are saying, there's nothing wrong with it, but it is most decidedly not what was done. That would be nice, and it would be constitutional. But what you cannot do, that advice, you can't have it after the fact. That's what's called ex post facto rationalization. What the president did, Justice Matopo, did in actual fact, was to say, I am appointing Professor Cachalia as an acting minister. And he says that not just in the announcement, as I've explained to Justice Chikri, he even says it in his answering affidavit. So he's clear about what capacity he was appointing Professor Cachalia into, acting minister. He cannot do such a thing under Section 91(3)(c), because Section 91(3)(c) is to appoint ministers per se from the general public or from the National Assembly. Where he can appoint him as an acting minister is under Section 98. But the problem he has there is Section 98 says, for me to make you an acting minister, you must already be a cabinet minister.
But you would be a cabinet minister in terms of 91(3). No. But you said it's, I think where I have a difference with you.
Yes.
Is you seem to be putting more emphasis on the appointment itself.
Yes, but...
On the announcement, sorry.
No.
Yeah, you seem to be putting emphasis on the announcement. Let me put it this way.
Page 91, paragraph 57 of the I think it's volume 1 or volume A, I think it's what it's called.
And that would be what, under which heading? Just
that's the first, page 91, paginated page 91, Justice Mato.
I need to get there. This is a very important point for me.
It is. No, it is indeed.
Yeah, what paragraph is that?
57, Justice. I've elected to appoint an acting minister of police from outside cabinet, as I'm entitled to do in terms of Section 91(3)(c). That's a misstatement of the law. Section 91(3)(c) does not entitle him to elect to appoint an acting minister of police. The section which he was obviously oblivious of, which entitles him to appoint an acting minister, is Section 98.
But Mr. Mpofu, I think we're quibbling with words. There is no way that the president could have appointed an acting minister from outside.
Well, that's what he says, under oath. So we must tell him he's lying. There's no way, but there's a way, because that's exactly what he did.
No, I can't take it any further.
Well, we wouldn't be here, Justice Matopo. The only reason we're here is because the President Ramaphosa says, I swear before God that I have elected to appoint an acting minister of police from outside the cabinet.
But is this not the debate that you have with my sister, Teron, that we put in form over substance?
Well, maybe. It looks like it is. But the point is...
But it looks more like it looks more like it, not any other way.
But no, Justice Matopo, with the greatest respect, what you are doing is actually doing the right thing, that no president in his right mind could appoint an acting minister from outside the cabinet in terms of 93(1)(c). We agree.
It is wrong.
Thank you.
Yeah.
Please. Shh. Justice Majid.
Mr. Mpofu, just exclusive jurisdiction. You rightly said that one must have regard to the pleadings to determine exclusive jurisdiction. Can I take you to paragraphs 13 and 14 of the founding affidavits, pages 9 and
1.3 and 1.4, yes. I'm there, Justice.
Yes. Now, you mentioned section 167(4) and you mentioned Nhlanhla and my vote count, but you don't mention section 83 there. What must we make of that?
No, but Justice Majid, with the greatest respect, yeah. The pleadings, when you say the pleadings, you mean the pleadings as a whole, not one paragraph. So section 83 is if you go to,
Can I just stop?
yes,
Page 9C, exclusive jurisdiction and direct access.
yeah,
Then you deal at 13 and 14 with exclusive jurisdiction. Then 15, you
yes. No, there's nothing wrong with that just sheet. All I'm saying is that when you look at pleadings, you look at the pleadings as a whole. So if you go to paragraph 39, you'll see where, 40 rather, yeah, where we outline the requirements of section 83, okay? And if you go to, where it says the president must uphold, defend, and respect the constitution as supreme law or whatever, then you'll also find in...
Mr. Mpofu, sorry to interrupt you, but I mean, here you're dealing with the merits of the case. You've dealt with exclusive jurisdiction and direct access. These you quote in the context of these three issues that we did.
Yes, but that's what it means when it says the pleadings. It means the pleadings, including the merits. The pleadings,
Is that your
as
answer?
they stand.
Is that your answer?
Yes. In Gaba, it says to find
Can I
jurisdiction.
go to the second aspect? I'm satisfied, thank you.
Thank you.
There was something that struck me in this case about the Commission of Inquiry.
Right.
And you mentioned earlier, the entire judiciary is tainted by these allegations.
The entire?
Judiciary.
Yes.
You even spelled it out, judiciary,
Yeah.
which includes the entire judges of the country.
That's what it says.
That's what you said.
No, that's what Mkhwanazi says.
Yeah, that's what he says, yeah. You say, therefore, Justice Nhlanhla is disqualified from hearing,
No.
from sitting in the Judicial Commission, because he's a judge. You
It's got
said it should have been a commission, and then it would have other problems.
No. It's got nothing to do with Justice Nhlanhla. It says there is a species of Nemo Judex called institutional
I
bias.
understand that. Yes.
So it's the institution, not Justice Nhlanhla.
I understand that. That's why I'm
That
saying,
is standing in the dock.
yeah. The entire judiciary is
in the dock.
disqualified as an institution.
Is in the dock, yes.
But why is the case in this court before the judges? How are we qualified to hear this case and he's disqualified as a judge of the institution to? I hope I'm not sounding facetious.
No,
But it just
well,
occurred to me,
I
oh, it's
want
a
to answer
different
that
thing,
question.
because we are asked to decide this challenge, which goes to the heart of the establishment of the commission. So how are we qualified, but another judge, a member of the institution, is disqualified? Qua judge.
No, but Justice Majid, you are qualified because you swore when you were being admitted as a judge to apply the Constitution of the Republic of South Africa. And we are saying here that in the leave of absence decision, the Republic of South Africa, the Constitution of the Republic of South Africa was breached. That's got nothing to do with Justice Nhlanhla or anybody. We say the appointment of Acting Minister Cachalia was unconstitutional and all the things that we say. That has got nothing to do with this. And we say in relation to the commission that the judiciary is conflicted. I'm putting it colloquially. Now, every time, in fact, when you do a recusal, you do it to the judge. So the judge can say, well, why are you asking me? What is that? Because the judge is compelled by his or her oath of office, even when the recusal is against him or her, to adjudicate it. So,
I don't understand it. I mean, you're talking about an institution, the judiciary, but I hear you. I hear your answer. Now, just lastly, you say, and I'm dealing with a leave of absence, because as you say, but for the leave of absence, we wouldn't have had an appointment of the professor. Now, you say there are only two possibilities in the exercise of his presidential prerogative. The president can only appoint and dismiss. There's nothing in between. There's no room for suspension or placing on leave, as he calls it.
Well, I say two things. I say, to the extent that leave of absence, there's definitely no power for the reasons that I've explained, because you can't place someone on leave of absence. But if you take Justice Theron's formulation to say, okay, well, let's arose by any name. Let's say it was a suspension. Then I've answered that. I referred the court to 177 to...
Can I ask you about 177 then?
Yeah.
Because we've heard that 177 deals with a judge being removed from office, and 194 deals with head
of Chapter 9.
of Chapter 9 institutions. Is the word suspension there not deliberately used because there are other actors at play here? It's not just the president who takes a decision, I'm going to appoint or dismiss a minister, but here we have the National Assembly that must, through a vote,
Sorry, Justice.
oh sure, must through a vote to remove them, a judge or a Chapter 9 institution
Right.
holder. Is that not the reason why the president is expressly given the power to suspend there? And therefore, there is no such express provision here, because it's his prerogative, it's his discretion, it's his power. He's empowered to do so without any outside actors like the National Assembly.
No, firstly, because even in the other, if you look at 194.3, 194.3a is also a prerogative, so that's not a reason.
There, the National Assembly plays a role. Do you accept that?
No, of course, that's for a different reason. That's because it's a punitive removal. And because it's a punitive removal, this court said in AFF 2, because it's a punitive removal, you must have a process, a disciplinary process, for lack of a better word. You must. It's necessary. That's where the necessity test comes in. There, you said, Justice Machiti Mncwabe, that the test is necessity. In those examples that are giving me, it is necessary because there has to be an inquiry. And that's why Justice Jafta and Justice Zondo, for that matter, even in the dissent in AFF 2, made the distinction between an impeachment and a motion of no confidence. The one requires an inquiry because it is punitive, but the other one, because it's a prerogative, in this case, it's a prerogative of Parliament, let's say, to remove you in a motion of no confidence. You don't need an inquiry, so it's not necessary.
And lastly, just on this, on the same topic, the Constitution says we must have regard to international law. It's noticeable, and within the limited time available, it's noticeable that of countries with constitutions more or less resembling our own, so yeah, I'm just leaving out the US for now, but Germany, India, Namibia, and Canada have no express provisions to remove, to suspend ministers or cabinet secretaries. The only one that does have, and through an act of parliament, is Kenya. Is there anything that we must make of that? In other words, in those jurisdictions, it's an implied ancillary power of the type encapsulated in Amabungane and the Madlanga J judgment.
No, the first part is correct, the second part is incorrect. It doesn't follow that because it's not mentioned in other constitution, it means it's an implied power. It means it's non-existent. So yes, it's true that in fact, to be fair, even in the so-called common law countries, because this thing comes from Britain in the end, there, because the two things, there's a culture of people just resigning when these kinds of allegations are made. We don't have that culture. But there is the Queen and the Prime Minister. It's said in typical British fashion, it's in the gift of the Prime Minister to have you as a member of the cabinet. But here, the point I was simply making, Justice, was that you can't imply, if you use the test that you gave in Mncwabe and the test that's given in Amabungane, and for that matter, the test given in Masetla. You can't imply that the power to place on special leave, assume there's such a thing, the power to place on special leave is so connected as the breaking of the egg when you are making the omelette in the example that Hoekstra makes. In other words, you can't make the omelette without breaking the egg. So you can't say you can't dismiss without leave of absence. That would be far-fetched.
That means that if a minister is accused in the public domain of something that's less serious than would have warranted removal, the president must then dismiss. There's no in-between. There's only appointment and dismissal.
Yeah, can dismiss or retain. There's nothing wrong with him retaining.
There's no via media.
No, there can't be. The only via media, it can't be in our heads. The via media must come from the law. That's what Fetcher says.
Thank you.
So Justice Mach, sorry to... It's an or not granting. If go to 150, this, while you're, let me explain to you why the president
Giving a reference.
yes, 158.
Okay, let's proceed with the questions.
Yes.
Otherwise, you'll never finish.
No, let me, well,
What are you doing there?
Wants to
let's,
and I found it.
yes.
Yes.
I'm saying that, look at the,
You seem lost. This is the Zweli Mkhize matter.
yes.
I don't know what the point is you want to make. He says he's pending the outcome of the investigation in the SIU final report.
No, let me, the point to make there is that, okay, the first sentence. So I hereby, with effect from 9 June 2021, grant Dr. Zweli Mkhize special leave of absence pending the finalization of the investigations and so on. Now, granting special leave is the correct thing. The president says this is the same as the Mchunu situation. It's not true. Because here he was granting. Granting special leave means,
Yes, thank you.
you get the point, yes. Dr. Mkhize must have asked for it, and it was being granted. Here, he says, I'm placing, in other words, I'm imposing. So this has nothing to do with what he's doing here.
Mr. Mpofu, just a quick question from my side. Following on your view that there's nothing between appointing and dismissal, because there's no express power.
Well-
No, can I finish?
Yes.
Nor is there an implied power. That's your view. Secondly, you argue that an implied power is only one that is necessary, correct? Is that so?
It has to be necessary.
Right.
Yes.
So could I just ask you, and you don't need to respond now, you can do so perhaps in reply.
Yes.
Is relying on Amabungani, which you have relied on. The judgment in Amabungani deals with an
Primary.
implied primary power or an ancillary implied
Correct.
power. What Justice Nhlanhla does in that judgment, he also then calls
special leave and the granting of special leave. Do you say that if a minister requests to be placed on special leave, the President has the power to grant that?
No, that's not what I'm saying. I'm saying,
So
sorry.
So there's neither the power to place on special leave nor the power to grant special leave on request.
Well, Justice Rogers, I'm not concerned. If there is a power to place, for example, for argument's sake, and I'm going to answer your question directly, I'm saying even if there was a power to grant, which I don't concede, there's certainly no power to place forcefully. Now,
So if there's a, I know you concede neither, but if there were a power to at least grant,
yes,
then that would have to be an implied power, because it's not expressly conditioned.
certainly.
So if a cabinet minister gets a cancer diagnosis and wants to take 6 months off for treatment, requests special leave, you say the President's only permissible response is to dismiss her from the cabinet.
No, that's not what I'm saying.
Well, if she says, I want 6 months special leave for medical reasons, you say the President doesn't have the implied power to grant that.
No, I say he doesn't. But I'm saying something more, Justice.
So if he doesn't have the implied power to grant, what can he do if the minister is going to be off for 6 months for medical reasons?
What can he do? Yes. In the best interest of the country, what he can do is to remove that minister. And when the minister, assign those powers to somebody else.
So the answer to my question was his only option would be to dismiss her.
You see.
Well, you can call it dismissal,
removal, withdrawal of the powers, yes.
A cabinet minister.
Yes, but I want to qualify my answer if I may.
My brother Majid touched on questions in other jurisdictions, also in the limited time I've had available, in jurisdictions which come from a similar parliamentary culture to ours in the way cabinets are composed, in the discretion of a president or a prime minister.
Yes.
Sometimes I appreciate nominally through the crown.
At the pleasure of the president.
The idea of ministers being on special leave is of frequent occurrence. And it can include for personal reasons, including medical. In Australia, there have been several instances where it is pending a commission of inquiry. So it, as an element of prerogative, it doesn't seem alien.
No.
And to the extent that our Constitution expresses the idea of appointing and removing cabinet ministers, it seems to be capturing, and I think your submissions mentioned the prerogative, it's basically expressing in words the prerogative of the head of the government to compose his or her cabinet.
Yes.
And if other countries allow, who live under a similar regime, have procedures for granting leave of special absence to cabinet ministers, why would it not be regarded as suitable here? Is it consistent with our Constitution, for example, to say that the only answer to an unwell cabinet minister is to remove them from the cabinet?
Well, the first answer is that we can't do it just because it's done in other countries. That's why we have our own Constitution. Otherwise, we should just go according to the constitutions of the world. The second answer is that, as I've said, Justice Rogers, our case is that even if, and therefore the debate then will not go anywhere, because we make that, let's call it half concession, to say even if the power to grant, as was exercised in the Mkhize example, exists, for argument's sake, we say even if it does, certainly the power to place somebody, to impose leave of absence to someone who has not asked for it, which is what happened in this particular case, does not exist.
I don't wish to debate it further, but the only relevance for us would be this, that if we find it incomprehensible that the President would not have a power to grant special leave in circumstances that he considered appropriate upon request by a minister, it would immediately involve finding that there is at least that implied power by the President to grant it,
Yes.
even though it's not expressed. And it might then not be a very far remove to say, in other circumstances that he considers appropriate, even when the Minister does not request it, he can bring about the same result. That's
follow that.
significance. I appreciate you've got stage 1 and stage 2, and if you fail on those 2 stages, you've still got the further argument you say that it was in any event irrational even if he had the power.
Yes. Thank you, Justice Rogers. If I may just, as I did with Justice Colapen, again, the one thing that I must not leave this court with anybody having an impression that I am saying is that the President can only fire or hire. I accept, as I must, that there must be other things in between which, if they are reasonably necessary, would be implied, such as the one you are postulating, such as the one I was postulating of saying, if he says, okay, I'm removing you, but I want you to spend another month to finish the school that you're building or whatever. Those things are clearly would fit within the doctrine of necessity. All I'm saying is that in this case, the doctrine of necessity has not been satisfied because this is not an impeachment. And this is where the problem is with the word dismissal, by the way.
The problem is necessity takes you really into the merits of what the President has done and the rationality or irrationality of what he has done, whereas the primary debate we have been having is about vires, about power. If there is something in between, if there are some circumstances in which the President can properly, as it were, suspend, place on leave, or accede to a request to be placed on leave, then that is the power, and it is part of a presidential power implied in his discretionary power to appoint and to dismiss. And then any attack on the exercise of that power has to go to the merits of his decision and the rationality attack, which you do make. It can't be expressed simply as a question of an absence of power.
No, I'm sorry, Justice Rogers, it's not like that. There is a clear overlap between the virus point and the rationality point on this issue of necessity. And the overlap is simply this, it's the nexus. If there is no nexus between the alleged implied power and the primary power, then the virus is not there. Similarly, if there's no nexus between the action that is taken and the purpose of the section, then it's irrational. So the necessity point overlaps both legs. Yeah.
My last question, and I will just write down what you say.
Yes.
In the in-between ground,
yes,
formulate to me at least one implied power which you say the President has to give effect to what you regard as necessary.
Yes, okay. I've said it.
And it mustn't be with reference to building a school, a specific case. It must be the legal formulation of a power such as one might write into a constitution expressly.
Well, it would say something like this. It could even, in fact, he has already done it now to Mr. Cachalia, where he said, I'm appointing you as the acting minister.
No, but that's fact-specific. Formulate an implied
power
in general terms.
Okay. The President may appoint a minister, but implied in that is that if the minister, for some reason or another, is not yet ready to assume office,
if the minister is not ready.
Is not ready to assume office, the President may grant a dispensation to give that minister 2 weeks to leave it, that's specific, to leave that place or whatever. So that's how you'd formulate it. It's very easy. In other words, I can't come here and say, why would the President say to Professor Cachalia, well, you must start now, because I've already appointed you and I have no, so you have to start. I don't care about your VETS thing. That would be ridiculous. Because that's, so the power can't exclude even those obvious necessary ancillary, whatever you like to call it, things.
looks like we've exhausted our questions.
Okay.
Thank you. Thank you. We need to hear the.
The other, yes, well, yes, I wanted to round off, but I'll do that in reply. Yeah, it's fine.
No.
Thank you. I'm indebted to the court for that.
Thank you, Mr.
As court, please.
Mr. Mpofu. Just a second before you start. Yes, Katz. Come through, Mr. Katz. Before you proceed, there's that document, the National Security Strategy. It's not going to be admitted. Don't even refer to it. Thank you.
Justice
You may proceed.
We have half an hour to divide our argument. I will deal only with the question of vires, whereas my learned friend will deal with the question that arise other than vires. In dealing with vires, I just want to make one quick precursor, and that is touching on a question that Justice Theron mentioned, which was the question of direct access. She put a very pointed question to my learned friend, and she said, could the applicants have gone to the High Court in respect of effectively 3.2 and 3.3? And he answered yes, but she didn't mention 3.1, correctly so, because they couldn't. I'll leave that point for direct access. Let me talk about vires. We've heard a lot of debate on vires, but our submission is that the debate hasn't focused on what the true import and conduct of a minister is in the South African constitutional setting. And I want to pick up on something that was debated this morning. The use of the word prerogative was thrown around by some of the justices and by my learned friend. And my learned friend said, well, there was an innumerable, attenuated notion of prerogative. That's not true. There is no prerogative. The Constitutional Court, this court in Hugo said, we had a past, there was a prerogative, no more. And Justice Rogers, when you say we can look at other countries such as Australia, which came from a similar parliamentary background, no. Australia had a particular parliamentary system, as these other Commonwealth countries did, Germany, Namibia, etc. They had their own histories. South Africa had a particularly difficult history, and our constitution is born out of that difficult history, no prerogative. Number one. Number two, when one looks at what does a minister do, just Matopo said, no vacancy. There's no vacancy when it comes to questions when it comes to ministers. And for this purpose, I want to talk to Chapter 5 of the Constitution and say Chapter 5 as a whole is the wording, the context, the purpose, and the history when it comes to, for example, the interim Constitution, tells us one thing and one thing only. There is no power to suspend. It's appoint, dismiss, nothing in between. There is no such thing as an acting minister. These ideas are anathema to the notion of what a minister does in the South African context under Chapter 5 of the Constitution. So let me take the court to Chapter 5, but before I do that, I want to just mention two cases. The one is a case referred to in the Minister's Heads of Argument. It's in paragraph 61 of the Minister's Heads, where he mentions a case called Implied versus Government of the Republic of South Africa, 1996, Siskar case. It's a judgment of Judge Heath, where Justice, well, then Advocate Nhlanhla, acted for the applicant. And the same issue arose in respect of a premier who suspended an MEC. And what the minister says is, like by like, there, Justice Heath, or Judge Heath, found that there was a power to suspend as an implied power. But what Justice Heath did was he analysed the Act, sorry, not the Act, the interim constitution when it came to Premier's powers. And one of the important aspects that we would suggest, which is different to this case, there the Premier had an obligation to consult before suspending, or before dismissing in particular. So the Premier could not dismiss, other than after consultation. Here there is nothing like that. Here, tomorrow morning, the President can wake up and say, the Springboks are doing well, I don't need a Minister of Sport. There's no punitive aspect, there's no hearing, there's no audi, it's wholly within the prerogative. So I use that bad word, prerogative. It's wholly within the discretion of the president. Wholly within this discretion. And if there is a power to suspend as suggested by the president in this case, oh well, let's see what the commission comes up with. Because I can't and I don't want to dismiss the Minister of Police because of untested allegations. That hamstrings the president in the way that he conducts his executive authority. It doesn't help the president, it hurts the president. So that's the first case that I want to talk to. The second case is Masetla. And this goes to the heart of what I'm going to debate. Masetla, there was a post, a constitutionally established post of head of particular institution. All the other cases, there are posts where a person is appointed to the post. In the case of cabinet, there is no post. And I take the court to chapter 5 of the Constitution to demonstrate that point. Because if there is no post as such, the entire debate that we've heard this morning must be seen in a different light. So if one starts with chapter 5, and it's the whole of chapter 5, it's not one particular section, and remember that chapter 5 contemplates an acting president in terms. So for example, if the president is outside the country, the Constitution says there's an acting president and how it works. No such provision for an acting minister. Why not? Because that's the constitutional structure. Whatever Australia might say, whatever Namibia might say, we have an acting president at times, no acting ministers. I mean, the simplest thing in the world for the Constitution to talk to an acting minister. But it doesn't. But it does talk to an acting president. So we start off there. Now, just on this, before I actually turn to chapter 5 in detail, the president says 91(2) is the power, the implied power. The minister says, if I understand him correctly, it's 91(2) read with 98. But my submission is a very simple one on the minister's argument. If 98 has any impact upon 91(2), it's the exact opposite of that which the minister purports, for the reasons that I'll come to. So let me just, that's the background. I know I'm going to go quickly. So the executive authority, 85, and then it talks to the assumption of office of the president. And 90, I've mentioned the concept of an acting president. And then 91, and here we start with all the difficulties that we submit give rise when it comes to the president and the minister's arguments. 91, the cabinet consists of the president, etc. 91(2), the president appoints the deputy president and ministers, assigns their powers. That's important. Assigns their powers and functions and may dismiss them. So what happens? There's no post of a minister of police. At the next election, the new president can have whatever cabinet he chooses. He can have 100, he can have 50, he can have 20. There's no post. So he appoints a minister, he assigns their powers and functions, and may dismiss. Then there's the 91(3)(c) debate that the courts had with my learned friend. 92, and one other question that I think Justice Cheeky questioned was, would Professor Cachalia be a member of cabinet were he to somehow become an acting minister? And the answer was yes. I'm not sure what the correct answer is, but it does seem interesting that if one had an acting minister on the one hand and a suspended minister on the other hand, both being members of cabinet, both would be subject to parliamentary oversight. Could Parliament call in, let's call it suspended Minister of Police Mchunu and say, we subpoena you, come to Parliament and tell us what's going on? Could they call Professor Charlie in the same way they could call any other minister? It's not clear. But it certainly gives rise to difficulties that aren't easy to have as consistent with the wording of 92. Because they're responsible for the powers and functions of the executive assigned to them by the president. Members are accountable collectively and individually. So is the suspended minister and the acting minister part of the collective responsibility? We would suggest not. That's not the way the scheme works. It's ministers who are in office, who are complying with their duties, functions, and powers who are part of this collective, let's call it responsibility to the people of South Africa. So we would submit that's where the problem starts. Deputy ministers are dealt with in 93, and the oath of office, etc. 97 talks to a transfer to a member of the cabinet. Let's just stop there. To a member of the cabinet, the administration of any legislation. B, any power or function entrusted by legislation to another member. And that must be done by way of proclamation. But now we talk to Justice Rogers' perhaps difficulty when it comes to the cancer minister, the minister ridden with some illness or personal crisis. 98. And this is what the minister talks to when it comes to giving effect to this notion of implied power under 91.2. This is what the minister says. This gives effect to 91.2's implied power. Temporary assignment of functions. So it's temporary. Who may it be given to? A cabinet member. Not somebody at Wits. It's got to be a cabinet minister who may be given a temporary assignment of a power or function of another member. When that other member, the Minister of Police, is absent from office or is unable to exercise that power or perform that function. So the whole idea of 98 is where one has a minister who is, for example, sick and is unable or absent from office to exercise his or her power or function, then the president may assign a cabinet member that power temporarily. And the president doesn't have to go through the proclamation fact, which he would have to do under 98. That's what section 99 says. A cabinet member may assign any power function that is to be exercised, etc. So now I turn to the question of what happened in this case on the facts, and I've got 3 minutes. One, if the president had no power to suspend, it was appoint or dismiss. And we say there can be no difficulty. The court has suggested the question, whoa, it's so difficult to have a situation where it's black or white. But we say not, the exact opposite is the case. It's easy to have black or white because he can dismiss the Minister of Police tomorrow for no reason, for good reason, for bad reason, as long as it's rational, in the interest of the executive authority for the purpose of the people of South Africa. So the president says, look, I need a good police service. I need policing to be done properly. While this minister is under investigation, it's not that I'm punishing him. It's just that I don't want him to be part of my cabinet. What's wrong with that? Nothing. And that's what he should have done, if that's the view that he took. So he says, well, I don't want to keep the minister here because it's not good for perception of policing in this country. I'll dismiss him. Next week, Justice Commissioner Madlanga comes up with a clean bill of health for the current minister, or the previous minister of police. The president can appoint him the next day. What harm has happened? Nothing. That's how it works. There's no need for suspension. The president can appoint on one day, dismiss on the next day. The first respondent knows that very well. The first applicant knows that well. And we can think of examples where a minister was a minister for a weekend because of the public outcry. And we're not talking about, maybe the man's name was Van Rooyen, I'm not sure, I can't remember. But that's not the point. The point is that's how the system is geared to work in our country with this constitution. So we submit, simply put, if the president has a problem with any of his ministers for whatever reason, he dismisses them, he transfers their powers to another member of cabinet, not somebody outside, And if it turns out that the person gets better, they recover from their chemo, whatever it is that they're having, he just appoints them again. It's as simple as that. Justice Nhlanhla, I've used up my half of my 30 minutes, and I hand over to my learned friend. Thank you.
Justices, thank you, and a good morning. That is taking a bit longer. I was fearful there might be a tea break just before I commence. But I think I can go ahead. Thank you very much. Justices, my only address is limited, considering all the submissions made by my colleagues. We are limiting our submissions only to two things: the establishment of the commission, the consequences of such establishment, the cost implications, the impact of the revelations by Mkhwanazi on state security, and the consequences that follow by taking the duties of the police and placing them directly on the powers of the commission. Now, Justices, before I even go anywhere else, I would wish to refer the court to page 33 of the record, which is MK1. Now, this would be the media statement that was issued on behalf of the judiciary as far as it relates to the allegations by Mkhwanazi. Paragraph 3 of this statement states the following. It says, in this regard, the Acting Secretary General of the Office of the Chief Justice has formally requested the National Commissioner of the SAPS and the Provincial Commissioner, Lieutenant General Mkhwanazi, to furnish evidence in support of these allegations and to lodge formal complaints where warranted with the Judicial Services Commission and the Magistrates Commission. Justices, I come to just these 2 points to say, if this court takes the very judicial point that if there are any acts or misdemeanors on the part of the judiciary, that such must be dealt with by the Judicial Services Commission and or the Magistrate Commission, it cannot be that on the same tone the court would say such powers must vest in the commission's work. Secondly, Justices, we say, in the event that the commission itself goes ahead and attends to the work that is envisaged under the complaints by Mkhwanazi, then what? We then go into the roles and the responsibilities of the police, and we say the responsibilities of the police as far as national security is concerned is to protect, is to investigate, and is to make sure that any misdemeanors that are complained of by General Mkhwanazi are addressed in a manner that the police ought to. And we are saying, based on the machinery of the SAPS, the constitutional rights and obligations vested in the police, if such are now taken and placed in the hands of the commission, is no less than usurping the powers of the machinery of government to deal with crime and related issues. Now, I once again would like justices to refer again to the very following paragraph. And this is what the court says. It says, these bodies are constitutionally and statutorily mandated to investigate complaints against judicial officers. And we say, justices, just by the fact that, one, the allegations and revelations implicate the judiciary, and the judiciary agrees and says, in cases where there is any ill conduct impugned on the part of the judiciary, the appropriate forum to deal with those becomes those specific arms. And we say, justices, that just on that fact alone, on the one point, it only serves to demonstrate that the setting up of the commission, with the scope that it has been given, does nothing except to usurp the powers of the SAPS and all other law enforcement mechanisms that have the equipment, the machinery, the investigative powers to come to the conclusion on whether or not a criminal conduct has happened. But justices, on the further leg of this argument is the following. When we look at the responsibilities of the police and we look at the investigative powers and the machinery that is vested on them, can we then say, if the commission does its work and comes back, Does that take away the duty and the responsibilities of the police? And we say no. Let's assume a report comes from the commission. The duty of the police, as we have seen in commissions in this country, is that they still have to go and do a fact-finding mission, satisfy themselves that there are tribal cases that relate to criminality or any other concern raised. So justices, that becomes my very first leg. And we say, justices, that in terms of national security, we say the president ought to act decisively. He ought to act decisively. And justices, I'm not going to repeat what my colleagues have said, but as a matter of fact, can the question of placing somebody on precautionary subscription on an indefinite period be deemed to have been rational? Now, justices, I have dealt in a more detail on the duties of law enforcement and how they overlap the functions with the new responsibility of the commission. And we say this can only create the confusion between the organs that ought to do their responsibilities vis-a-vis what is being given to them. Now, if we leave for a minute the issue of the police, and we look squarely at the constitutional prerogatives that deal with judges, at how judges ought to be dealt with in cases where there is some instigation, something is wrong, there's criminality here. There is only one institution that's been established, justices, and there can be no ground whatsoever to take away the functions and duties of the Judicial Services Commission and or the Magistrates Commission and expect that such powers can now be vested in the Commission. In fact, if anything at all, what would simply happen, Justice, which is what we are fearing at the end, is that the cost implications would have quadrupled simply because, one, the Commission would have incurred its own cost in doing the work, and once again, the JSC will have to sit down and do the same thing. Because I do not foresee, Justice, the situation where tomorrow there are commissions of inquiry and the JSC says, well, we are happy with it, we go ahead as it is. It would still have to sit down, analyze the issues, go through the facts, and go through the motions that are required in terms of the Act. And so we submit, justices, that just on that basis alone, the powers of the JSC cannot, including those of the SAPS, be usurped by the establishment of the Commission of Inquiry. Now, justices, I have also dealt a little bit, and this is my last point that I wanted to highlight. I also wanted to highlight the cost implications that we're talking about. Of course, we have dealt with the first cost implications relating to three ministers, 3 ministers of police at the same time, and 2 deputy ministers. And we are saying in the economy such as ours, justices, there's no way that any rational decision would warrant the president to have in his own cabinet 3 ministers of police. So the cost implication does not only limit itself to the Minister of Police's portfolio, it also goes to the second leg of costs that are occasioned as a result of the establishment of the Commission. And we are saying, just on that point alone, there is no way that the cost would become justifiable when the president ought to have simply taken a decision which my learned colleagues have already alluded to. Now, once again, Justice, I need to emphasize very importantly that the criticism of the Commission of Inquiry has nothing to do with the persona before it. The persona before the Commission of Inquiry is beyond reproach. But what we say is that there is an allegation and revelation of wrongdoing on behalf of the judiciary. If we look at the actual statement by Mkhwanazi, he says, we have got evidence of 1, 2, 3, 4. And we are saying, now what simply becomes the consequence is that law enforcement in KZN or wherever it is where they've done this work must now sit and live all the work that they're doing, because the same work cannot be done by the Commission on the one hand and by the police at the same time. So all the machinery, all the work, all the past researches that the police would have made to come to the conclusion that they have today would have to be duplicated, causing a massive and impossible and insurmountable task as far as costs are concerned towards the taxpayer. So the criticism, justices, is only purely limited to the principle that one may not be a judge in their own cause. And once again, this has nothing absolutely to say to saying, well, the acting deputy judge president might find that it's a colleague of mine. And then we come to the process of, okay, if it's a colleague of mine that I'm close to, now I have to recuse myself. We are saying this would simply make it impossible from any arm of government, let alone the police and the very JSC, to conduct its business efficiently. Justices, I think these are the 2 points I wanted to make before you, and if there are any questions, I'll be happy to take them. Okay. Yeah. Thank you very much, Mrs. Court, please. Oh, God, I'm telling you. I don't know why every time I'm supposed to put them down. Oh.
Yeah, there are too many. There used to one time. There are lots of cheers here. Yes.
If I understood your your submissions correctly, does it mean that if there are allegations leveled against a minister or ministers, and those allegations, depending on their nature and severity, are serious, as in the instant case, the president has no option but to dismiss, and if down the line the allegations turn out to be false, he can, in his discretion, appoint or reappoint. It's that how I understood you.
That's not our submission.
Okay, put
Our submission is this. If there are serious allegations made against a particular minister, then the president has the discretion either to keep the person in the cabinet or to dismiss.
yeah.
In exercising that discretion, the president will take into account whatever factors he so chooses in making that decision, such as the allegation is made by somebody who is a political opponent and therefore I'm going to ignore it. Or somebody who's a senior police officer, that's serious. As factors, that's for the president to decide. And he decides, it can never be the case that he has no option but to dismiss. So he has a wide discretion.
Your mic is.
Let me repeat. Our submission is the president will always have a discretion to dismiss or not to dismiss. And he will, the president, will take into account whatever factors he deems appropriate for that decision-making process. And a factor could be who is the author of the serious allegations? What are their nature? How does it affect cabinet in general? And that's what the president will decide. How much time is there before now and the end of the next term of cabinet? Let's say it's a week before cabinet's due to expire. Should he take it into account, that fact? Yes or no? It's for the president to decide. It's now 2 years. When's the next national election? I think it's 2.5 years from now. It's a lengthy-ish period. So those are the kind of factors that the president will take into account, etc.
Now I don't understand you. The more you explain, the more it becomes so difficult for me to comprehend. Because you're bringing personalities who would have complained, also the duration of the term of office of the minister.
Of the president.
Of the president.
Yes, of the president. Now, what I'm saying is this. The president is the person who decides whether to dismiss or not. And Justice Matopo, you put to me the question, is it the case that the president would have no option but to dismiss? And I said, no, he will always have an option to dismiss or not to dismiss. And the president is the person who decides what factors come into play in making that decision.
Sorry to interrupt. What factors, if any, would the president consider whether to dismiss or not to dismiss? Is that the inquiry?
That's the inquiry. Well, no, it's for the president to decide that question.
So if this president says, once the allegations were made against Minister Mkhwanazi, I underwent the same exercise that you are now alluding to. And in my discretion, decided that I'm giving him leave of absence. Forget about what it means. It's another area that we have to debate. Can a president do that?
No.
What is it that he cannot do?
Excuse me?
What is it that he cannot do then?
You can dismiss, or you can keep him. That's all you can do. That was my argument. It's black or white. There's a person who allegations have been made against, serious allegations or otherwise. The president will consider the charges, whatever they are, against the particular minister, and he'll decide. The cabinet should continue to operate with this person or without this person.
And if he does not dismiss, as in this case,
then he can...
Then what?
Well, he can do a number of things. He can, if he decides not to dismiss the minister, say it's a Minister Mchunu in particular, he could, for example, under his powers, in the chapter, assign different functions and powers to Minister Mchunu and have a different person take over the functions of the Minister of Police.
And
As an example,
what becomes of Minister Mchunu?
He goes-
You reshuffle him.
he goes to do tourism or home affairs or some other power or function. That's the point. He's still a member of cabinet. He's a member of cabinet and he's been assigned certain powers and functions.
So this is the interpretation that you'd contend we must read into.
91.2 read
Yeah.
section 98, yes.
So it's too strained.
We say that any other alternative is too strained. This is the proper interpretation. This is not a post. We spoke about Masset.
No. The post we've moved away from it. We're talking about the position as a cabinet minister.
Absolutely.
Yeah. We are on one page there.
Yeah. So if
On your understanding, if the president had moved Minister Mchunu from his portfolio and maybe placed him as a minister of tourism and what, you wouldn't be here.
no, well, we wouldn't be here for the reasons that we.
I mean, you for the second application.
No, I'm saying the second applicant wouldn't be here on the basis of why we're here today. Certainly not. No, we're here because he suspended him, not because he moved him or gave him leave of absence or whatever form of a substance. He suspended his functions, exercising his powers and functions as a member of cabinet. That's what he actually did, as opposed to suspended him from cabinet. And Justice Cheeky, I think you touched on really the difficulty well, I'm not sure you spoke about it in respect of.
No, you still addressing me.
Yes, but I'm coming back to your point. Is the Minister Mchunu, now that he's, let's call it suspended or leave of absence, however we call it, is he a member of cabinet today? That's the question. And if he is a member of cabinet, that's problematic for a whole range of reasons, because he sits in cabinet meetings on a Wednesday morning. That's problematic. Is he a member of cabinet or isn't he?
But he would be given leave of absence. So if leave of absence would mean he's not going to be attending any cabinet meetings in his place, if there's a new minister, the new minister would attend cabinet meetings.
Well, that's the point, Justice Matopo. Why would he be given leave of absence without dismissal? There's only one reason rationally that it could be, that he keeps his benefits. There's no other reason, because he's not exercising any powers or functions. None.
Can I tell you what my difficulty is?
Yeah.
If the president were to act the way you suggest on allegations, I'm just worried that we could be plunging this country into some sort of a situation that is difficult to contemplate. Because if allegations were to be made by persons in the same caliber as Lieutenant Mkhwanazi, it means against maybe 5 or 10 cabinet ministers. It means on your construction, they have to either be reshuffled or sent home.
Justice Matopo, you've actually, with respect, you've actually hit the nail on the head. Let's assume there are 10 cabinet ministers who are fingered by the police commissioner, the provincial minister. Would all 10 be suspended and 2 new acting people come in? Or 20? Where does one draw the line? That's the problem. So it's worse if he has to, it's worse from you put it to me, Justice Matopo, we'd be in trouble if he had to do what I suggest is the way forward. I submit we'd be in serious trouble if he could do what he's done. That is, suspend when there are serious allegations made every single time it happens. That's exactly the point. I put it on reverse, jiu-jitsu. It's worse for the president if he has to do if he can do what he's done in the way that he's done it because there's serious allegations. Let's say tomorrow there's a serious allegation against Minister of Home Affairs. Tomorrow's Thursday, Friday suspends him, appoints an acting minister in Home Affairs. Monday, serious allegations against the Minister of Finance. Tuesday, suspension.
No, but it does not necessarily follow that if such a scenario were to present itself, the president always acts in terms of section 91.3c. He may or he may not. And 91(3)(c) gives him not more than two persons.
Well, there's a debate as to whether those two. There's the simple proposition, and I'm not dealing with that for the moment. I'm talking about the question of suspension. Justice Motopo, you said to me, it would put the president and the country in a difficult position if every time there were serious allegations, the president couldn't suspend but would have to dismiss. I'm answering that question, that debate. And I'm putting the opposite proposition, that were the president be allowed to suspend every time there's serious allegations, you could have the whole cabinet suspended, effectively. I mean, you just think of it. The whole cabinet could be targeted by political opponents or serious people. And then the president said, well, I suspend the whole cabinet, they're all on gardening leave.
But the corollary is the whole cabinet could be dismissed.
Yes. And you get a new, that's what, he dissolves the cabinet, he gets a
But
new
then it's chaotic. Then on the interpretation that has been advanced by the respondents about leave of absence, suspension, one must accept that the president may have had a one-on-one with the minister.
Yes.
And try to ascertain or ascertain his version.
Yes.
He would have to do that. And after that exercise, decided to say, okay, I'll put you on leave. Or the others could be, after that exercise, to say, let's put corrective measures, maybe.
There are no corrective measures when it comes to no post. There's no post. You don't put corrective measures. It's a simple question of, I'm the president, I want to work with these 10 people for the best interests of this country. That's how it works. It's not a corrective measure. That's the whole point. Maseta and all these cases, corrective measures where art is involved and et cetera, et cetera. This is not a corrective measure putting him on, let's call it suspension, leave of absence or whatever. This is to protect the integrity of cabinet, they say. Well, if you protect the integrity of cabinet, dismiss or not.
Okay.
That's the argument.
No, we've belabored it. That's fine.
Mr. Katz, my questions are meant for Ms. Kofa.
Okay, okay.
Libakeng.
Well, unless Justice Nhlanhla, maybe all the questions to me can be asked, and then I'll sit and...
Yeah, there are no questions for...
Are there no more questions for me?
No more for-
As a please. Thank you.
Justice Chief, I'm bringing my laundry back, just in case I need to refer.
All right. Can I call you Ms. Libakeng?
Absolutely, Justice.
All right. I'm interested to know what you were saying is the alternative to the Commission of Inquiry. You were saying that instead of a Commission of Inquiry, then there could be individual investigations. Were you saying that? On the prosecutorship, on the magistracy, on the judiciary, and on all the implicated.
Justice Chiki, what I was trying to go into as far as that issue was concerned was to demonstrate the point that if the functions and machinery that rest under the police gets given to the commission, that only seeks to demonstrate the usurpation of the powers that vest within the JSC as a body responsible for dealing with any issues affecting conduct of judges and so on. So my submission is not that the commission is not appropriate. In fact, if I remember well, Mr. Mpofu used the words to say we need to try a distinction between a judicial commission of inquiry and a commission, because simply.
So your complaint is the constitution of a judicial commission of inquiry, not the composition of a commission of inquiry.
No, absolutely.
Okay, now I understand you. Now I understand you. Thank you.
Thank you, Justice.
Now, on that point, if the concern is the appointment of a commission, the judicial commission, which is going to be headed by a judge, because you're saying the judiciary is implicated. And who's going to investigate the judiciary if it's an ordinary commission of inquiry, especially since the JSC and the Magistrates Commission is constituted of, amongst others, members of the judiciary?
Absolutely, Justice. Maybe let me break that question into two parts, because that's exactly what we are saying. Let me break that question into two parts. When the JSC sits to deal with any concerns relating to ill conduct, and however one can define it, on the part of the judges and or any member of the judiciary, it is because the people who would be sitting there to adjudicate would be the people who are not disqualified from adjudicating the dispute. The composition itself would be able to say, okay, there's an issue before the JSC. I mean, I do not foresee a situation where justice, there would be a situation where Mr. Mpofu is the one who is sitting as the decision maker before the JSC, and he's investigating himself in the same instance. I believe that the same order of the workings of the JSC would take effect. Not that the JSC is not qualified; it absolutely is.
If any member of the SJC, in particular, members of the judiciary, who happen to be members of the JSC, are implicated, you are saying those who will have to recuse themselves.
Absolutely.
And allow the remaining members to deal with whatever allegation that are there against the judiciary.
Absolutely, Justice. In fact, the truth is that even General Mkhwanazi's statement says some members of the judiciary. He doesn't say the entire judiciary is tainted. So I mean, to that effect, I would assume that in a situation where there has to be an inquiry into the conduct of judges, the composition that is legislated to give proper adjudication to those issues will be properly constituted. We do not want to take away at all from the roles and the functions of the JSC. We cannot do so.
Thank you. Mr. King, yes, you argue that the JSC is custom-built to deal with these type of matters, correct?
Yes, indeed, Justice Cachalia.
As I read the JSC Act, it seems that the common thread that runs through it is that it deals with complaints about the conduct of judges.
Indeed.
And it contemplates a complainant and a respondent,
Yes.
and it provides for the mechanisms then to deal with that. On any interpretation, what we have currently that's been put into the public domain by Lieutenant General Mkhwanazi is not a complaint about the conduct of judges. It's an allegation about corruption in the judiciary. So that's my first issue. And well, maybe you could just deal with that. Well, let me ask my second question because it's linked to that. Secondly, as I understand it, the terms of reference of the Commission, and I don't have it here, would not include making a finding of the kind a tribunal would make against any judge that, let's assume, is implicated in evidence before the Commission. It certainly seems to be compatible with how the two systems work for the report of the Commission to go before the JSC. And the JSC can then look at a complaint about the conduct of judges. So my question really is that these don't appear to be incompatible processes, and the one speaks to the other. And in any case, I'm not sure how on what is currently the allegations made, the JSC will, in terms of its own structure, be able to convert that into its complaints handling procedures. Thank you.
Thank you very much, Justice Cachalia. What we do in our heads of argument is to almost dissect, and I'm not going to quote directly from the terms of reference, Justice Cachalia, but what we do, we try to highlight the powers of the Commission, which include investigating, research, including amongst others, drafting reports and making recommendations. So we say, just on the first leg of the inquiry and the job of the Commission, it automatically overlaps. So we are not saying we should separate the two. We are saying there is an obvious Justice Kolapen. Let me take you to the letter, to the first letter. I think it's Annex MK2 to the founding papers. If you'll indulge me, Justice Kolapen, I just want to refer you to the appropriate letter. There it is. Thank you. It is MK5 at page 47. Forgive me for that wrong reference. When we look at the content in this letter, what it simply seeks to do is to deal with the concerns that have been raised. First, yes, indeed, on the part of General Mkhwanazi and the implications there too. What we then do, and I would like to refer specifically to paragraph 3 and paragraph 4. And I'll not deal with the issue of the agency of the matter. It says the matter concerns the desired invalidation of events such as the assumption of office of the acting Minister of Police, which defect on 1. It is well accepted that the Constitutional Court is not ordinarily suited to hear agent applications. But no, I don't think this is the appropriate paragraph. Forgive me. Forgive me, Justice Kolapen. May I just hold this a minute for my colleague to help me with the actual reference of the paragraph. The CJ. Oh, yes. Okay. Forgive me, Justice Kolapen. The document we are supposed to refer to is MK2.
That's a statement by the President.
By the Chief Justice. That is MK1.
Yes.
That is at MK1, page 33. And Justice, I'm not going to repeat the answers because I've already read most of these extracts into the record. But I think the answer simply that I will refer Justice Kolapen to will be truly in the entire letter, paragraph 2, 3, and specifically the last part of paragraph 4. The last part of paragraph 4.
Okay. Oh, thank you. Just my last question. Are you saying that if anybody in complaining about public maladministration, could be the issue of healthcare, could be anything, refugees and asylum seekers, simply alleges that the corruption and maladministration extends into the judiciary, that on its own would be sufficient to preclude the President from appointing a judicial commission, just on that basis? That would be the consequence of your argument, not so?
Well, I think Justice Kolapen, I would not agree in those exact terms. What we are dealing with here is an actual statement relating to specific revelations and allegations made
against the judiciary,
amongst others.
No, let's look at it. It says these things that I've uncovered also reach the judiciary.
Indeed, Justice.
We don't know whether it's judges, we don't know whether it's magistrates, but he says it reaches there.
Yes.
But it's in the widest of terms. So someone could say that there's a tender fraud that involves members of the judiciary, and that would be sufficient just on its own. And I'm not suggesting that the judiciary should not be investigated. There are mechanisms and structures. But on your argument, that would preclude once and forever and for always the President from appointing a judicial commission.
That is why, Justice, we are saying we believe that the appointment of a Judicial Commission of Inquiry ought to be done very carefully. I mean, otherwise we'll be having as many as we would have once there's an issue. They keep mounting and mounting. But what we're simply trying to demonstrate is that there are certain allegations that are made that are far removed, whose gravity may not warrant the establishment of a Commission of Inquiry. We take absolute notice of that. And we are saying when the circumstances so allow, and in this case, once again, Justice Kolapen, we're not saying, as I stated in my earlier submissions, we hold no issue with the composition of the Commission of Inquiry as established. What we are saying is there is a principle that says one may not be a judge in their own cause. And we are saying to that limited extent, the criticism of the establishment goes to that part.
Okay, thank you very much. Even though the JSC Act on which you rely violates that very principle, because the tribunal that exists would consist of 3 members, 2 of whom would be judges, investigating judges.
That's the JSC, Justice Kolapen. That is the constitutionally mandated body to deal with those type of issues. And the only gripe I have here is to say, if there is a constitutionally recognized forum where certain acts and or misdemeanors ought to be investigated, that ought to rest within that organ. And we are saying to avoid not only duplication in costs, but duplication of the work itself, let the appropriate issue be addressed by the body constitutionally mandated to do so.
Thank you very much.
Thank you very much, Mrs. Kolapen. Thank you very much. Thank you.
Mr. Manager.
Thank you, Justice Nhlanhla and Justice of the Court. I think my mic is on. Yes. Between me and my learned friend, Ms. Hofmeyr, we're going to share the submissions for the President. So I will deal with the merits, which is the 3 decisions, and Ms. Hofmeyr will address the jurisdictional questions. We propose to deal with our order slightly different from how Mr. Ketz and Ms. Lewakeng dealt with their submissions. I will take the 20 minutes and then exhaust the submissions, take questions, and then leave the chance for Ms. Hofmeyr to take her 10 minutes and take all the questions and conclude our address.
We prefer to finish with the uninterrupted time.
As a court.
Let's hear you. Once your 30 minutes is done, we come in. We'll say we want you, then we will deal with you, and then at a later stage, if we have questions for Ms. Hofmeyr, she will come in and respond.
I will abide by that.
Thank you.
Thank you. Then I deal first with the first issue of powers that relate to, with the position of Minister Mchunu, and then I'll address the position of Professor Cachalia because they follow in logically, and then I'll deal with the issue of the Commission. On the question of the powers, firstly, in relation to Minister Mchunu, we have dealt with this at page 18 of our heads and following, and we commence our submissions by accepting the obvious, which is that the executive powers of the President in Section 91(2) of the Constitution do not include an express power to place a minister on leave or to suspend a minister. So there's no power expressly stated. But as everybody accepts, that is not the end of the inquiry. What we invite the court to determine, and which we will submit, is that there is an implied power that authorizes the President, either as a matter of substance in this case, to place Minister Mchunu on suspension for a period of time pending the outcome of a Judicial Commission of Inquiry, or as the President has used the phrasing, to place him on leave, which Minister Mchunu has accepted. So the distinction sought to be drawn between the request for special leave and being placed on special leave is much of a muchness because the Minister accepts being placed on special leave. We have referred, as all the other parties have done, to the Mabungani judgment of this court, which discusses the distinction between ancillary implied powers and primary implied powers. We rely primarily on ancillary implied powers, and we rely on the paragraphs in the judgment from paragraph 63 to 68, in which that judgment also references and relies upon the judgment in Masetla, at paragraph 68 of Masetla. So the contention of our learned friend, Mr. Mpofu, that Masetla is a different context, there was an employment, there was a post, is irrelevant to the extent that we're dealing with the question whether there are implied powers or not. The principle is the same. And the judgment in Amabungani at 63 to 68 indicates that the concept of ancillary implied powers and how it arises is formulated in different ways. Sometimes it's formulated as a power that is necessary for the proper exercise of the power, existing power, and that existing power can itself be an implied power or an express power, because it could be a primary implied power, or it could be a power implied because it is ancillary or incidental to the primary power, or its corollary. I always have difficulties with the R and the L's and which comes first, but or is the corollary of the power that is expressed. But in all those instances, what is clear is that it is a power that is either necessarily required for the proper exercise of the given power, or reasonably required, as Justice Colopin reminded us, but always it is for the proper exercise of the power that is given. And we will be submitting that to place Minister Mchunu on special leave is a power that is necessary or reasonably required for the proper exercise of the power to dismiss. And I'll come to why we say it is required for that proper exercise of that power. That's the first argument we make. The second argument is that one can derive the power by reference to the power to assign powers, and that's my secondary argument. The main argument derives from the power to dismiss. And the Section 91(2) in relation to the power to dismiss makes it very clear that it's the President may dismiss, emphasizing the discretionary nature of that power. Now, and it's a wide discretion, but as was said in Masetla and has been said in many cases, that a power conferred by the Constitution, the exercise of a power conferred by the Constitution is not unconstrained. So the power itself is not unconstrained. There are constraints to the power, and in this case the power to dismiss, and the constraint would be that it must be exercised lawfully, rationally, and in a manner consistent with the Constitution. Now, one asks, why would a power to place a minister on special leave or to suspend a minister pending the outcome of an investigation be a power necessary or reasonably required for the proper exercise of the power to dismiss? Is that there will be circumstances in which there are, as in this case, serious allegations which are made against a minister. And the President, as the minister testifies in his answering affidavit, engages the minister, and the minister denies the allegations. And the President says he is not in a position to decide, to exercise the discretion to dismiss without those allegations being investigated. And we would submit that that need for investigation in that context is to enable the President to discharge the power to dismiss in a manner that is consistent with the Constitution and the requirement of the principle of rationality. Because the principle of rationality requires that the process leading to the taking of the decision, in this case the dismissal of the minister, the process must itself be rational, because it must inform the President properly on whether there is a basis to dismiss. And the President says, I can't reach that decision lawfully, consistently with the Constitution, without giving the opportunity for those allegations, broad allegations, being investigated. And we submit that in that context, that power to place a minister on suspension or place him on leave in order to test wild allegations made in this sense is properly a power that is necessary for the proper exercise of the power to dismiss. In the absence of the implied power, it would mean that in every instance where there are serious allegations made, the President, in truth, has one option only. I know the contention is the discretion is always there, but it's a non-discretion when he can't take a decision in between keeping the minister or dismissing the minister. So if the allegations are so serious that they may result in the credibility of the cabinet being questioned, and keeping the minister is not justifiable, they say the only option is to dismiss. You can't allow for any in-between position. Our learned friend, Mr. Mpofu, seeing the obvious difficulty with that argument, accepts that there must be an in-between, but the in-between cannot be a power to place on suspension or to place on special leave. And when pressed as to what the formulation would be of an in-between power other than, which would not permit of a power to place on leave, he can't, other than go into specific facts and say maybe in that fact, on those facts it may be necessary, but not on those facts, but not to formulate an objective rule that would be applicable from in different set of circumstances, because the existence of the power can't depend on facts. The power exists, it is the exercise of the power that may depend on facts, or whether on particular facts is necessary to place somebody on suspension or leave or not. And we submit for our learned friend Mr. Katz to say, well, if one accepts our proposition that absent the power, the implied power, the only option is to dismiss, and he says, well, on the other side, if you have the whole cabinet alleged of criminality, then you would end up suspending the entire cabinet. Our response to that is that neither of those propositions answer the question of powers. It's simply to illustrate really that it might be a difficult terrain when it comes to the actual exercise of the power, but it doesn't say the power doesn't exist because in certain circumstances it might result in the entire cabinet being dismissed. Obviously, in properly exercising the power to dismiss, the president would take into account whether dismissing the entire cabinet is the appropriate response or not. But that doesn't really answer the question of powers. And so we submit that on the principle in Masetla, this is a power that is reasonably required or necessary or ancillary really to the greater power as a lesser power to dismiss. That's the first source of the power. The second source of the implied power is to look at section 91 2, that the section doesn't only give the power to appoint and the power to dismiss. There is a power in between those two, which is the power to assign powers and functions to ministers. And you will see when read in conjunction with section 98 shows that the assignment of powers to specific ministers may be taken away on a temporary basis and assigned to other ministers also on a temporary basis, as in section 98. So here, what that shows, and we submit, is the power to assign, the power of the president, the express power to assign powers and functions, includes as a corollary to that power, the power to unassign the powers that have been assigned to a specific minister. And when the minister is unassigned, has no powers assigned or has been unassigned powers, that minister, as in this case, is excused from performing their functions or exercising their powers, as in being placed on leave, pending the outcome of an investigation. And in those circumstances, then their powers may, on a temporary basis, be assigned to another minister under Section 98, either an existing minister, such as in the case the assignment of those police powers and functions to Minister Mantashe to act in the interim, whilst Minister Mkhwanazi's powers have been suspended, so to speak, or unassigned for the temporary period and he's at home on leave. Or, as I will get to Professor Cachalia, where you might have somebody appointed from outside who then becomes a cabinet minister and is assigned temporarily those powers whilst the Minister Mkhwanazi is on leave. Both of those provisions we submit provide a basis to source the implied powers of the President to place a minister on suspension or on leave. Both Section 91(2) in relation to the power to dismiss, and the same section in relation to the power to sign and unassigned powers and functions from ministers. There was a question raised about, well, what about cabinet or ministerial accountability during Minister Mkhwanuzi's leave of absence? During his leave of absence, he is excused from performing functions as a cabinet minister or exercising powers as a cabinet minister. Accountability to Parliament is for the exercise of powers and the performance of functions. If he's not performing functions and exercising powers, he is not also accounting to Parliament. He's excused by being placed on leave or on suspension. Then the next issue regarding Minister Mkhwanazi is the question of the lawful exercise of the power to place him on leave, which is the rationality challenge, really. They contend, the applicants, that that decision is irrational, but we remind the court, as it knows, that irrationality sets a very low threshold. It's quite easy to meet. All we need to show is that there is a rational connection between means and ends. And what the applicants try to do is to limit the President's reasons to those that he gave in the public address, and say that anything that he adds in his answering affidavit is an ex post facto rationalization which is not permissible. But that's just wrong, because the application here is not a review. It's not a proceeding where the President was asked first to produce his reasons, which he declined to do, and now faced with a challenge tries to come up with new reasons. This is a direct challenge without offering the President an opportunity to provide reasons. And the President, facing a challenge, has given chapter and verse of his reasons for placing Minister Mkhwanazi on leave, pending the outcome of the Commission of Inquiry. And it's important just to go to the affidavit of the President to see what he says those reasons are. Because in addition to the reason that he gave, we're not running away from the reason given in the public address. That reason in the public address was to enable the Commission to perform its functions properly. Now, Minister Mkhwanazi sits at the heart of the agency that must be investigated. He is the Minister of Police. He is responsible for the police, and in his office there are staff members, there are documents which may be relevant to the Commission of Inquiry's investigation. In long dealing with precautionary suspension in the context of employment, it is proper governance in those circumstances to say, I'm taking you, allegedly the wrongdoer, out of your office, so there is no opportunity to intimidate witnesses, either actively or just staff thinking the minister is still here, how do we cooperate with the Commission, or to make documents disappear, those sorts of things. So it's good governance to take him out, and it's justified. So that reason given in the public address is just as good on its own, but there are additional reasons that the President has given, and you will find that from page 85 of the bundle, I think that must be A, from paragraphs 42. He says, my decision in this case was informed by the seriousness of the allegations implicating Minister Mkhwanazi. Those allegations raise the question whether the Minister Mkhwanazi has breached his most basic duties under Section 96 of the Constitution, which include his duty to remain faithful to his oath of office. They also raise the question of whether Minister Mkhwanazi has engaged in criminal conduct. I therefore considered it necessary to remove Minister Mkhwanazi from his position, to take his current powers away from him, the point I was making about unassigning powers. Take the powers away from him, and to do so pending the outcome of an investigation into his conduct through the Commission of Inquiry. I also did not consider it appropriate for Minister Mkhwanazi to be moved to a different portfolio. He He deals with the reshuffling, which they say was his option. He considered it. The seriousness of the allegations against Minister Mchunu meant that he should not be exercising any powers while on suspension. The allegations have profound implications for public confidence in the executive and the police force as a whole. So I decided that a proper investigation into the veracity of the allegations was warranted. That is the height of rationality. It is not at all something that falls below rationality. The Old Book judgment, which our learned friends also referred to, say, it is not the function of the court to say you had a number of different options. The one you've chosen is not the most optimum. It is only to ask whether the one chosen bear any rational relation to the purpose that is given for that power, the power to place on suspension or to dismiss, to protect the integrity of cabinet, credibility of cabinet, to allow for proper investigations so that the truth is determined and an exercise of mind can be made by the President on whether or not to dismiss Minister Mchunu ultimately. So that's the position of Minister Mchunu. Then the position of Professor Cachalia. With respect, our learned friends, the court, in a different context, Justice Matopo asked my learned friend, but you seem to be placing all reliance on the President's speech. And he said, no. But indeed, it is the case. So there are...
Mr. Manager, you said you'll take 20 minutes and the 10 minutes
yes.
For your counsel.
Indeed.
I think your time is up now.
Yes, I appreciate that. Then when I come back, I'll start from the position.
Provide.
Thank you, Justice Nhlanhla and Justices of the Court. As my learned friend, Mr. Maineche, indicated, I will be dealing broadly with jurisdictional issues. And in that regard, there are three topics I propose to cover. The first is to spend some time considering the underlying rationale and constitutional placement of Section 167(4) of the Constitution. The second will be to look at the pleaded case of the applicants for their asserted claim of exclusive jurisdiction in this matter. And then thirdly, to spend some time on Section 83B of the Constitution, which seems to be the last vestige of the applicant's case for exclusive jurisdiction, and to look more closely at what EFF1 said about that section. And then finally, time permitting, to deal with direct access. Justices, this matter does not fall within this court's exclusive jurisdiction. Very few matters do, and this is not one of them. This court has previously had occasion to consider Section 167(4) in the Constitution, and it has said that it must be narrowly and restrictively construed, and that is for essentially three reasons. The first reason is because cases that engage this court's exclusive jurisdiction come to this court first and last. No other court may opine on those issues. And there is a wealth of jurisprudence of this court recognizing how limiting that is in a situation where the court does not have the benefit of any other court's considerations of these weighty issues. And I would add to that, doesn't have the benefit of the refinement of legal argument and issue over time as matters wend their way through the courts. None of that is available to this court when it exercises its exclusive jurisdiction. And so that itself is a reason narrowly to interpret that provision. The second reason is because 167(4) of the Constitution is followed by 167(5) of the Constitution. And so it is critical to interpret sub 4 in the light of what sub 5 says. And if we could just turn to that for a moment. Today we're dealing with 167(4)(e). That one, the exclusive jurisdiction of this court, says only the Constitutional Court may decide that Parliament or the President has failed to fulfill a constitutional obligation. That's the one aspect of exclusive jurisdiction on which the applicants pin their case today. But if we look immediately at what 167(5) says, you will see there it is also concerned with conduct of the President. But there it deals with jurisdiction that this court shares with other courts. It says the Constitutional Court makes the final decision whether an act of Parliament, a provincial act, or, and this is the emphasis, conduct of the President is constitutional, and it must confirm an order of invalidity made by the Supreme Court of Appeal, a High Court, or a court of similar status before that order has any force. What that means is that 1675 recognizes an appellate jurisdiction for this court in matters involving the conduct of the President. And if that is so, that is the express term of 1675, then when you are dealing with what 1674E covers, it must be something other than stock standard conduct of the President that is attacked for being irrational, biased, beyond his powers. It cannot be of that ilk, because that type of jurisdiction is a jurisdiction that this court shares with others and in respect of which it is only exercising its appellate powers. And then the third element of this court's prior treatment of section 1674 is to emphasize the special role that separation of powers plays when this court is exercising its exclusive jurisdiction. Those matters under 1674 engage the separation of powers in a different way to the way in which standard conduct of the President engages separation of powers. And what that means for this case is that you aren't in 1674E territory if all you're doing is complaining about the lawful exercise of the President's powers. On the contrary, you have to find a specific constitutional obligation placed on the President which has not been fulfilled in the given case. And Justices, this was not referenced in our heads of argument, but I'd like to draw the Court's attention to the recent judgment of this Court, penned by Justice Rogers in the Tembani decision, because at paragraph 101 of that judgment, Justice Rogers says, in essence, in summary, the point that I've been making to this Court until this point. There, the Court holds, exclusive jurisdiction is likewise not engaged where the President is said to have exercised some or other power in a manner which conflicts with constitutional principles, such as the rule of law, binding on all persons vested with public power. The essence of that reasoning with respect is that you cannot hook in this Court's exclusive jurisdiction if all the case is about is conduct of the President. And Justices, that takes me to the point of pleading, because there is no more than that as the pleaded case for this Court's jurisdiction in this matter. Justices, Justice Majid, in fact, took my learned friend to the 2 paragraphs in the founding affidavit where jurisdiction is addressed. They are only 2. They appear from page 9. They are paragraphs 13 and paragraph 14, and there is no identification there of a constitutional obligation specifically and primarily placed on the President, which it is alleged he has not fulfilled. All that these 2 sections talk about is conduct of the President and an allegation. It's not even an argument with respect, it is a statement that there will be argument in due course about why the case falls within the Nhlanhla and My Vote Counts cases. So as a matter of pleading with respect, there is no case made out in the founding affidavit for this Court's exclusive jurisdiction. The final point is to remind this Court with respect about what was said in EFF 1 about section 83B. The reason I must go there is because in the heads of argument of the applicants, eventually some effort is made to grapple with some foothold for the exclusive jurisdiction of this Court. The 2 paragraphs in the founding affidavit did not do it on any reasonable reading of those paragraphs. So now by the time the shoe pinches of heads of argument, vestige is taken in 83B. But Justices, as this Court recognized in EFF 1, 83B on its own is not enough to ground this Court's jurisdiction. It has to be coupled with a constitutional obligation in respect of which there is a failure. And as one will recall, in EFF 1, the constitutional hook there, the constitutional obligation specifically identified as not being fulfilled, was the obligation of the President to act in accordance with the remedial action of the public protector. That was, in the words of this court, the primary obligation, in respect of which, when it was read with 83B, this court was satisfied it had exclusive jurisdiction. In this case, there is nothing beyond 83B, other than complaints about the conduct of the president. But as this court held in Tambani and has said in EFF, those are not cases which fall within this court's exclusive jurisdiction. They are cases that ought to start in the High Court because they are the standard basis upon which exercises of public power are attacked. Justices, if that were not so, the consequences for this court are very serious. Because cases of exclusive jurisdiction, this court can only determine. If this court in this judgment widens its jurisdictional ambit to take this case, it will likely mean, amongst other things, that all powers that are granted to the President under the Constitution, powers to assent to bills, powers to call for national referenda, to pardon offenders, to confer honours, will come here and only here as this court of first and final instance. And that would make a mockery of the prior jurisprudence of this court. Albert was a case dealing with the presidential pardon. It started in the High Court appropriately. It came here on appeal. Man Singh was a case about the presidential conferral of the status of silk. That started in the High Court. It went to the Supreme Court of Appeal, and then it came here under 1675. And that is my time, Justices. I will deal with direct access if there are questions in my question session. Thank you.
I'm hoping for questions.
Oh, sir.
Justice Majid?
Yes, just on direct access. Now, the argument is that this is a matter of important national concern, which just as an ordinary citizen it is, but legally, why do you say that if we accept that there's no exclusive jurisdiction just for the moment, why do you say this case doesn't warrant direct access, given the fact that it goes to national security and that it implicates a wide range of actors, even the judiciary?
Justice, because many, many cases involve matters of grave constitutional significance. But our constitutional scheme says those start in the High Court. The High Court is where you go. The High Court moves urgently, more easily than this court does. This court sits on bank, and often with as many as 11 judges. The cut and thrust of the High Court is where you start those cases. You do it in the urgent court if you have a case for urgency, and you do it on matters of free-ranging constitutional significance. You don't get any lesser order out of those courts, but you get the benefit of a reasoned judgment from that court, and that judgment can only inure to the benefit of this court's ultimate consideration of the issue. So we don't deny that these are issues of public importance, but we say the constitutional scheme, because 1675 recognizes conduct of the President and challenges to it begins in the High Court, is where those cases start. So this court has the benefit of those initial judgments on the issue.
Just as a follow-up and a last question, much was made about the fact that Professor Cachalia is supposed to start on 1 August.
Yes.
Is there anything significant about that date?
Not at all, Justice Majid. Not at all. Any issues with with Professor Cachalia's appointment can be dealt with in due course, as this court has dealt with appointments such as that of Mr. Nklasane in the previous case thereafter. There's no magic in the fact that it will commence in 2 days.
The applicants raise a concern that if they were to have gone to the High Court, there would be a problem with time constraints. If one party is not happy with the outcome, the appeal processes, and there's a date, there's a deadline there, the 1 August issue. What do you say to that?
Justice Nhlanhla, I've addressed the 1 August issue. In our submission, it is a non-issue because there are processes to deal with the irregular exercise of power thereafter, and there is a wide range of remedial option available to a court presented with the case. But if I can pick up on the point about cost, Justice Nhlanhla, the answer is 1675. 1675 says these cases start in the High Court. They must, because this court must be approached in an appellate role after the benefit of lower courts dealing with these issues. The fact that a disgruntled litigant in the High Court might see fit to appeal can't undermine what the Constitution said about the very specific preserve of this court exercising exclusive jurisdiction. And Justice Nhlanhla, if I can say it another way, if cost in the process of moving up the courts was a reason to invoke this court's exclusive jurisdiction, this court will never do anything other than exercise exclusive jurisdiction.
Can be in a position to approach the High Court and ask for the matter to be heard as a matter of urgency.
Absolutely. Justice Nhlanhla, in essence, that goes back to Justice Theron's set of questions to my learned friend this morning. Of course, they can move, the High Court can be moved on the most hyper-urgent basis. The next morning, if the circumstances of that night, if the circumstances of the case warrant it. They could have gone there. Our argument is they ought to have gone there because they cannot come here under the court's exclusive jurisdiction. But we also say they cannot come here under direct access because all of those opportunities to get their interim order if they had a case for it, to get a proper ventilation of the vires, rationality, etc. aspects on which they attack the President's decision, could have occupied the High Court, could have, and we'd say further, appropriately should have occupied the High Court.
Thanks, Ms. Hofmeyr. I understand and I appreciate, and which I have to accept, that the High Court can be approached as a matter of urgency, and so can the Supreme Court of Appeal. I'm asking this not on exclusive jurisdiction as such, and I'm not sure whether my question falls under direct access or urgency, because both are relevant in this matter. There's the urgency issue,
Indeed.
which is why we're in court today, and then there's direct access. I'm just worried that this proposed commission at the moment has been given a life of 6 months. And I'm just worried that even if the applicants can then approach the High Court and then Supreme Court of Appeal and then this court, whether they will be able, when they ultimately come here or to the Supreme Court of Appeal, to be in a situation where the commission is not complete. And because once the commission is complete, then the horse would have bolted.
Indeed, Justice Leakey, if the applicants have a good case for stopping the work of the Commission in its tracks, they can bring that case. You can interdict, as a matter, conceptually, you can interdict the running of a commission if you have a good case for it and you get before a High Court on its urgent role and you convince that court that on the balance of convenience, there is such prejudice to the continuation of that Commission of Inquiry as compared with the consequences of permitting it to continue, that you obtain your interdict. That is conceptually available, and it is an answer to any allegation that down the line prejudice would already have occurred, horses will have bolted. But you have to have a good enough case. I would submit that case would be a difficult one to meet, but it is arguably available. The point for jurisdiction and direct access is you make that argument in the High Court. It's suited to it. You have to meet the requirements for interim interdicts if you are to get it. But if your case is overwhelming, and remember, the prejudice will only exist if the case is overwhelming, then you will get your interdict in the High Court, and you can prevent it running.
Ms. Hofmeyr, I accept that one might have to show irreparable harm if one was seeking an interim interdict in advance of a determination of the lawfulness of the President's decision to establish the Commission. But if the matter were litigated urgently on the merits in the High Court, and the High Court found that the President's decision was irrational or unlawful, and therefore declared the establishment of the Commission unconstitutional. We know that wouldn't take effect until confirmed
Indeed.
by this court. But Section 172(2)(b) says that a court which makes an order of constitutional invalidity may grant a temporary interdict or other temporary relief pending a decision of the Constitutional Court on the validity. As I understand it, that would mean that after having found the establishment of the Commission unconstitutional and pending the decision of this court, the High Court could interdict the Commission from operating.
Absolutely, it could.
Now, at that stage, what would the test be? Would it still be irreparable harm? Or given that the High Court had now done something within its jurisdiction to declare the Commission unconstitutional, what then would be the test? Would it be a matter of essentially just and equitable relief?
Justice Rogers, it's an extraordinarily interesting question in the scheme of Section 172's creation of powers for the courts. Because the determination would already have been made by the High Court that there is an unlawfulness in the making of the decision, that will create in our submission a weight on the side of the case in favour of potential suspension, and the governing test would be one of justice and equity, not the irreparable harm that ordinarily has to be achieved, where you are seeking the interdict first up and you don't have the weight of the court's already determination as to unlawfulness. Because remember, just to add to that point, when the interim interdict is sought, there is no final determination on the ultimate legal question. It is done at a prima facie level, which is why that, coupled with irreparable harm, is the right test for the interim interdict from the High Court. What we are postulating here is a situation where the High Court has already made the final merits decision. That, in our submission, means the test would move to a justice and equity determination.
Yes, because part of my concern with direct access, and I don't express any views to what should happen in this particular case, but one senses a contention that because it has to be confirmed by this court, nothing effective can happen until it reaches this court. And it would be dangerous for us to set a precedent which said that the High Court cannot stop things.
Certainly.
If it can deal with the merits urgently, it seems to me that if its finding of illegality in the establishment of the Commission is a finding it's made, then I would think that prima facie it should prevent the Commission from operating until this court makes a decision. But so with any other conduct that has to be confirmed.
So with any other conduct that must be confirmed, it cannot be so that having made that determination, the High Court closes its eyes because there is a provision of the Constitution requiring confirmation from the very real prejudice, assuming such a case can be made out in the interim.
Well, I mean, take the case of a provision in the Refugees Act, say it was amended to allow a deportation to happen.
Absolutely.
In circumstances that expose the deportee to prosecution in the return country. Seems unthinkable that the court, having declared the provision unconstitutional, would not interdict the government from acting on it pending confirmation.
Indeed, and what would no doubt weigh with it is this point, to go back to Justice Cheeky's question, of the ultimate impact of a period of time in which things run, right? If the prejudice is so overwhelming, having already made the determination on the merits, there could be no proper construct of this constitutional scheme that didn't give the High Court a power exercising the rubric of justice and equity to do something in the interim.
The argument perhaps against it is that, of course, the High Court might get the answer wrong and dismiss the application,
Yes, but that
and they wouldn't get their interim protection.
Indeed, but there are always risks in our system of wrong judgments. That fact shouldn't determine constitutional interpretation.
Thank you. Just briefly from my side, Mr. Mayor, do you read Section 91 to create an obligation on the part of the President to appoint the Deputy President, ministers, and assign powers and functions to them?
No, we don't read it as an obligation.
Okay, because 91.1 defines the cabinet, not so. It says the cabinet consists of the president, as head of the cabinet, deputy president, and ministers. So how can the cabinet not come into existence if the president has no obligation to actually appoint the deputy president and ministers and assign? Because if that is permissible only, then conceivably we could have no cabinet.
Well, it would require a reading of 91.1 that reads in the words that inform the discretion in 91.2. So the cabinet consists of the president as head of cabinet and such deputy president, the deputy president and such ministers as appointed by the president in terms of...
No, sure. My point is simply that the president doesn't have a discretion. He has to appoint the deputy president and he has to appoint at least 2 ministers.
Yes.
All we have is ministers in plural, not so.
Indeed.
There's no limitation on. And so that's a constitutional obligation that the president has. Not so.
Yes, apologies, Justice Colopin. What I was answering was the question whether in all instances there is an obligation. I readily accept there has to be some constitution of a cabinet in its bare minimum, but not every instance of thereafter appointments, assignments of functions and dismissals is an obligation.
Sure. Now, the applicant's case is 83B, and they say that the president doesn't have the power to dismiss. And they argue that, well, their case for exclusive jurisdiction is they're not solely premised on 83B, but on the president not fulfilling a constitutional obligation.
Yes.
And as I understand it, their argument is that the power to dismiss is not peremptory, but if the president elects not to dismiss, then he can't do anything else. Well, that wasn't Mr. Mpofu's argument, but certainly Mr. Katz's argument. Would that be sufficient to get them into exclusive jurisdiction?
Certainly not.
Why
If I could deal with it in 2 parts. I think it's very important to understand, first of all, what the first applicant's argument is in relation to duty. Because, Justice Colopin, I listened carefully to my learned friend, Mr. Mpofu. Every time Mr. Mpofu goes to section 91.2 in the course of his argument, he uses the language of power. I took particular note. He talked about it being constitutional power bestowed on the president. He describes it as a prerogative power. He even went as far at a point to talk about it being in the gift of the president to give it. For as long as you are in the world of powers and are describing them in this way, you are describing quintessentially discretionary powers. And those are a far remove from the constitutional obligation, the failure to fulfill it, which engages this court's exclusive jurisdiction. So my first point, if I may, in response to Justice Colopin, is just to frame the first applicant's case is actually a case antithetical to this court's exclusive jurisdiction, because it is a case premised on a recognition of the, I think they even describe it as unfettered prerogative power, i.e. discretion on the part of the president. If I can then move to Mr. Katz's argument, which is more narrowed. In essence, Mr. Katz, as I understand for the second applicant, says, well, there are 2 options. You ping-pong either between dismiss or keep on. But even then, Justice Colopin, the only basis on which the exercise of the power in this case has been attacked is a vires point. That's Mr. Katz's argument, as I understand it. It's vires. He has 2 options only, and he did something in between. But questions about the vires nature of the exercise of a power by the president is stock standard conduct of the president that 1675 of the Constitution says goes to the High Court, and in respect of which this court only exercises appellate jurisdiction. So even on Mr. Katz's more narrowed argument for the second applicant, exclusive jurisdiction is just not engaged. They don't have that quintessentially constitutional obligation that implicates the separation of powers in a way different to ordinary conduct of the president to ground this case before this court.
Ms. Hofmeyer, something worries me. I hope you'll clarify it and put my mind at ease. You've had a debate with my brother Colopin, Jay. Section 167(4)(e) talks about the president decide that the Constitution and this court may decide that Parliament or the president has failed to fulfill a constitutional obligation. Following the debate with my brother Kolap and Jay, you say the constitution of the cabinet by the president, is it a constitutional power or a constitutional obligation?
It is a constitutional power because he has a discretion to select who he appoints into those positions, what he does when
No,
he
let's start right at the beginning. For him to establish a cabinet,
Yes,
for assigning those powers,
yes.
is it a power or an obligation? Remember, the president is elected. After being elected, the president then sits and say, now I must constitute a cabinet.
Yes.
What is that? Is that a power or an obligation? The Constitution says, once president you are appointed, constitute a cabinet.
Yes. If I may answer it in two parts. As in my engagement with Justice Collipin, 91(1) requires there to be at least a president, a deputy president, and a cabinet of 2 ministers. Right. That requirement may well invoke an obligation on the president. And were the president to fail to do that, because we are not in discretion territory, we are in obligation territory, it is conceivable that you have the type of constitutional obligation that Section 167(4)(e) is concerned with. But then we go on. Having done the bare minimum that 91(1) of the Constitution requires to have been done for there to be a functioning national executive, beyond that, the President is at large, unfettered, to continue to appoint more, to assign them particular functions, and to dismiss them when required. And we say amongst the exercise of that discretionary power to do things like suspend when there is good reason to do so. Those are not obligations placed on the President. Those are powers given to him. He exercises and must do subject to the strictures of the law. But when he fails to do them, you run to the High Court. You get the High Court to give you your remedy, including your interdict if you have a case, and you come up to this court only thereafter. It's not, if I can just emphasize, no part of our argument today for the President suggests that his conduct is immunized from attention and judicial scrutiny. The only question for the purposes of my argument is whether challenges to the way he exercises his power must come first and last here. And we say there is no reason for that to be the case in this set of circumstances.
Just bear with me. Let me look at my notes. So on exclusive jurisdiction, if I understand you, you would say this case, it's not about any obligation. It's about a disagreement of how the president exercises his powers.
Yes. And as is all other reviews of conduct of the president, of organs of state, every time a court sits in judgment of the vires, rationality, and alleged bias in decision-making, it is considering whether power was lawfully, constitutionally exercised. And we say that is no different in this case because it's conduct of the president in the exercise of a power that we are concerned with today.
I had expressed provisionally strong and firm views when
Yes,
when
I took note.
on direct access.
Yeah.
I'm not sure if I've moved or not. I don't take long to express my views.
I see that, Justice Matoba. I hope I've maybe just given you pause for thought at this stage.
You have.
Thank you, Justice.
So you reckon the public importance of the matter could have been entertained at the High Courts?
Certainly. There are manifold cases of great constitutional significance that appropriately start in the High Court. Justice Matopo, this court has said in its own judgments how its workload is crippling currently. The expansion of its jurisdiction means it is a court that should be engaged as a court of last resort, because that advances the administration of justice. Justice Matopo, there is such importance behind this point. The administration of justice requires this court to sit when it must sit and to deal with its extraordinary backlog that it currently faces. If this court can be the court that every litigant comes to when it alleges that there has been some irregular exercise of power by the president, all the other cases that legitimately must be here, the cases in which this court must sit as an appellate court, get shifted down the roll. And that, in our constitutional scheme, is reason to be very cautious, as this court said in EFF 1, about taking on. Former Chief Justice Mkhwanazi spoke about the monopoly power of this court. This court must be concerned about taking for it, as a court of first and last instance, cases that should come up to it from the high courts. There's a special preserve for this court. And unless it sets its limits in this case, we would say the administration of justice more broadly can be imperiled.
So if you are correct with your submissions on both, then it would mean that the applicants don't come home at all.
Correct.
And what would become of Professor Cachalia's appointment? He'll take office?
He will take office, and the reason...
And the commission will commence its...
Indeed. And that is the consequence, Justice Matopo, when litigants go before the wrong forum. It is just simply the consequence. If you go before the forum that didn't have jurisdiction, you suffer this consequence. These applicants put together the case for this court's jurisdiction in 2 paragraphs of their founding affidavit, 2 paragraphs. This is such an important issue, and they devoted 2 paragraphs to it. If they are wrong, they will suffer that election, that they came here instead of running to the High Court, giving much less notice, because that High Court can move itself more quickly than this court can, and deal with that forum.
Would we be accused of ducking the issues?
Certainly not. On the contrary, Justice Matopo, with respect, this court will have properly set the limits of its exclusive jurisdiction, and that will inure to the benefit of this court's ongoing jurisprudence and its ability to manage what comes to it.
Okay, thank you.
Thank you, Justice Matopo. Thank you, Justice Nhlanhla.
Mr. Manager,
Thank you, Justice.
my question is on the appointment of Professor Cachalia.
Yes.
In the answering affidavit of the President, I'm referring to paras 52, 55, and 57, page 90 and 91.
Yes.
The President has given different explanations. In para 52, let me wait for you to get there. Mr. Mpofu referred us to para 57, where the President said, I'm appointing Professor Cachalia as acting Minister of Police. I'd like to take you to para 52 first.
52.
52.
Yes. Yes.
In para 52, he says, I'm entitled to appoint a minister from outside of the National Assembly in terms of section 91(3)(c) of the Constitution. My appointment of Professor Cachalia as a minister will be made in terms of this section. That's what he says at 52. Then at 55, he says, upon his appointment as a minister, I will assign, Professor Cachalia will be assigned Minister Mchkunu's powers and functions as acting minister. Then the confusion comes in at para 57, where he then says, I'm appointing him as acting minister in terms of section 93(1)(c).
Yes.
And we know you don't appoint an acting minister in terms of that section. It's a fully fledged minister. I think that's the argument about
Yes.
the applicant.
Yes,
Please clarify this.
that's right. So I'll give the court the structure of the affidavit, and which will show that the answer is consistent and is in line with the Constitution. There's a very innocent explanation for the sentence that our learned friends like very much, which says, where does it start? I have outlined above the reasons why, given the nature and seriousness of the allegations against Minister Mchunu, I have elected to appoint an acting Minister of Police from outside of Cabinet, as I'm entitled to do in terms of sections. You'll see sections 91(3)(c), and in the drafting, and 98 fell off. But I can't make the argument purely on the basis of something that is not in the affidavit. What I need to show to the court is, so firstly, Professor Cachalia has not been appointed minister yet, acting or otherwise. And there's a simple reason for that, and that will be found in section 96(2) of the Constitution and section 101 of the Constitution. So section 102 says, 96, members of the Cabinet and deputy ministers may not undertake any other paid work. And then 101 says, a decision by the President must be in writing if it is taken in terms of legislation or has legal consequences. And the President has explained that when he appoints ministers, he does so by way of a President Act, and he's attached an example in the affidavits. So the explanation of the President in the answering affidavit is that he will appoint Professor Cachalia when his term at VETS ends on the 31st of July and becomes available to take up a position as a cabinet minister, because then he doesn't have two salaries. And that appointment will be done in terms of 91(3)(c) as a minister from outside. And when he is appointed, he will assign him the powers of police to act in the place of Minister Mchunu. And that is evident from the affidavit, and I'm going to give the court the way the affidavit is structured so that that can be followed. You'll see from page 88, the President, under the heading, my decision to appoint Professor Cachalia as the acting minister. He starts off by referring to section 98. So he's aware of section 98. And then he says, 48, the placement of Minister Mchunu on a leave of absence created a lacuna in cabinet, leaving open the critical position of Minister of Police. It goes without saying that I was compelled to take the necessary step to address this lacuna. Then he talks about the allegations. Then at 51 he says, given the importance of the role of Minister of Police and the potential for the allegations made by Lieutenant General Mkhwanazi to undermine the legitimacy of our law enforcement structures, I deemed it appropriate to appoint a person from outside the existing cabinet to occupy the position of minister for the duration of Minister Mchunu's leave of absence. So that's a temporary duration. This would remove the possibility of the allegations pertaining to law enforcement officials from tainting or being perceived to taint the South African police and other agencies. 52. I'm entitled to appoint a minister from outside of the National Assembly in terms of section 91(3)(c) of the Constitution. My appointment of Professor Cachalia as a minister will be made in terms of section 91(3)(c). This will be done in terms of President Act under this section. 53. I chose to appoint Professor Cachalia in particular because of his in-depth knowledge of and experience in the security cluster. He served as member of the executive. He explains that I don't need to read to the court. Then he says 54, Professor Cachalia is, however, available only after his retirement from his current position on 31 July 2025. In order to ensure continuity of the portfolio of the Minister of Police, as I assign the powers and functions of this portfolio to Minister Mantashe for the period until Professor Cachalia becomes available to assume these powers and functions. I refer in this regard to Annexure AA6, being my President Act appointing Minister Mantashe as Acting Minister of Police for this purpose. You'll find that at page 161. I don't need to take the quote there. Then he says, upon his appointment as Minister, Professor Cachalia will be assigned Minister Mchunu's powers and functions as Acting Minister of Police, given Minister Mchunu's absence. And then 56, I acknowledge that the appointment of Professor Cachalia as the Acting Minister of Police, pending the outcome of the investigation by the Commission of Inquiry, has cost implications. The expenditure of additional resources for the appointment of a person from outside Cabinet could, however, only be avoided by assigning Minister Mchunu's powers and functions to an existing minister or to appoint a deputy minister as a minister to enable such assignment. So he took that into account. I'll skip 57 for the moment because that is where the controversy arises, and take the quote to page 99, paragraph 102. He says, I have explained above my reasons for the appointment of Professor Cachalia as the Acting Minister of Police, as well as the provisions empowering me to do so. As I have addressed, Professor Cachalia will be appointed as a minister in terms of Section 91(3)(c) of the Constitution, and then assign the powers and functions of the Minister of Police to enable him to act in this position. So if you take the confusing sentence out, it's not clear as mud, it's very clear that the President is very aware that he has to act in writing on the 1st of August when Professor Cachalia is available, first to appoint him as minister and joins cabinet, and to assign him the powers and functions of police so that he feels what the President calls a lacuna in the police because Minister Mchunu is on leave, to act in that position for as long as the Commission of Inquiry, as long as he requires the outcome of the Commission of Inquiry to make a decision on whether to dismiss Minister Mchunu or not. And the fate of Professor Cachalia obviously depends on the President. He might think he has performed so well, he must stay there. Minister Mchunu comes back but gets water and sanitation or some other portfolio. All of that is in the discretion of the minister. Minister Mchunu is an adaptable minister. He's served in various portfolios. It's a serious matter that I'm making. At paragraph 57 then, to the controversial sentence, he says, I have outlined above the reasons why, given the nature and seriousness of the allegations against Mr. Mchunu, I have elected to appoint an acting Minister of Police from outside Cabinet, as I'm entitled to, and I've mentioned the sections. But he invites the court, he invites the reader of this affidavit, when you read 57, to read back. And reading back, you see the clarity that I just submitted. And after that, he carries on. Furthermore, Professor Cachalia is meant to hold this position for the duration of the Commission of Inquiry, which is intended to complete its work with the urgency that it deserves and in a maximum of 6 months. It was based on these considerations that, mindful of the expenditure associated with the appointment of Professor Cachalia, I deemed this expenditure justifiable in the circumstances to maintain the legitimacy and integrity of the criminal justice system. I'm advised that this is a judgment that falls in the heartland of executive functions. It involves a value judgment balancing competing interests over which reasonable people may differ. The parties here show you that. But that reasonable people may differ is not a basis for this court to interfere. So the point, really, the simple point is, in the first instance, when the court asks itself, can Professor Cachalia take up a position on the 1st of August under the Constitution? If objectively he can, there's nothing to invalidate because he is not in that position yet. The announcement of the President is nothing more than I've identified this person to be the one who's going to act as the Minister of Police. But the appointment itself, which is the act which is taken under the Constitution, has not yet happened. If it doesn't happen, this all is academic. If it happens on the first, it happens consistently with the Constitution. This, with respect, is the worst of the challenge, must rank as the worst of the challenges. Because former President Zuma knows how you appoint ministers. You do so by President Act, because Section 101 of the Constitution says so. He knows the empowering provisions, and he can read the affidavit, and it's very clear. Other than with great respect to my learned friend, you don't read an affidavit that way. You don't read one sentence and say, even when the paragraph invites you to read back, you just read one sentence and say, well, this is the height of irrationality. It's not.
Thank you, thank you. Justice Majid?
Just on this question of the appointment of Professor Cachalia, Mr. Manetje, is there room to read Section 91.3, Section 91.2, the President appoints the Deputy President and Minister and assigns their powers and functions as one continuous act. In other words, you appoint the Minister and immediately assign the functions. Because Mr. Mpofu argues the alternative to that is a Minister without portfolio, which is unknown in our system, he says. Is there room for that argument?
No, there's nothing in the Constitution which says that's one transaction. It's very conceivable that the President can appoint and then assign functions. There's nothing wrong in that.
If he appoints Professor Cachalia, just for argument's sake, on the 1st of August, Minister of Police, can that happen sort of in one flourish, in one presidential act? In other words, he says, I hereby appoint Firoz so-and-so Cachalia as Minister of Police. Can he do that? In terms of the
Justice Majid, yes, he can. He can say, in the same presidential act, I appoint, sorry, I was just clarify something, not as Minister of Police, as acting minister. He can say, I appoint Professor Cachalia as minister, and I will assign the powers of police, or I'll assign to him the powers of police, and he gets sworn in. But it'll be so in the way the question is put is a simultaneous act, but in effect it's sequential, even though it appears in one paper. It may be on the same day that he gives him the first appointment, and the same day he gives him the second appointment, the second assignment of functions and powers.
You see, that's what bothers me. You can't appoint an outsider as an acting minister. We know that.
Yes, yes.
So how he purports to do this, or plans to do, let me not say purports, that sounds a bit harsh, plans to do this, is to appoint him a minister, and it must be thereafter appoint him an acting minister. Now, let's say the presidential acts are two of them, separated within an hour. 10 o'clock a minister, and at 11 o'clock an acting minister.
Yes.
That hour or so he's a minister without portfolio. Not so. I mean, they're not splitting hairs because this is important constitutional principles.
So let's just pause for a moment. So we would submit that there's nothing in the Constitution which says there cannot be a moment in time when there is a minister without an assigned function. Because there may be instances where he's got an existing minister, existing cabinet minister, but he's considering reassigning that minister, but hasn't yet made the decision finally on which portfolio he's going to assign that minister. On the argument that you can never have any moment in time, fleeting moment, when a minister is without a function, it would mean for that moment that person is not a minister. So and that argument flows from this, that a minister, you can't have a minister without assigned functions. Well, portfolio is slightly misleading, because portfolio suggests it's police, but you could take away an aspect of the policing portfolio to give to someone else, like it happened with energy and electricity in that moment when they were kind of. But generally, you don't have situations where a minister is is sewn in and you don't know yet what the portfolio is. It doesn't happen. But I submit with respect that it would be the height of sophistry to say, legal sophistry to say, 10 minutes ago you were given the appointment to be minister. 10 minutes later you were given functions. There's a time when there was an invalid occupation of office or appointment. With respect, those would be, it might even be a de minimis kind of breach if there is a breach of that kind.
Just one last question. Mr. Mpofu pointed us to sections 177, 194, with this question of no express provision for suspension. And he didn't argue it, but I think the suggestion is that he cited those two examples where there's express provision for suspensions on the basis of the principle inclusio unus est exclusio alterius. That's what the implication is. What do you say about that argument?
There is a reason why those presumptions are only guidelines for interpretation, because there are circumstances when you depart from them. If that argument was correct, Masetla would have been decided differently, because in Masetla you had the power to appoint and you didn't have a power to dismiss. But there are many places in the Constitution, at least the one we are dealing with today, where the Constitution expressly confer a power to dismiss. Only argument is, where the Constitution wants you to have a power to dismiss, it says so. You can't imply it where it is not said so. But Masetla went exactly the opposite direction. So it is simply, that expressio unius is simply a guideline for interpretation. The ultimate question that the court has to grapple with is whether we are correct to say the proper exercise of the power to dismiss implies the power to suspend, to enable a president to properly exercise the power to dismiss. And so when I argued the point, the argument we make is this, is that the president has the express power to dismiss, but that power is constrained under the Constitution. It must be exercised rationally, meaning both in respect to reason, substance, and process. When the president is confronted with allegations and he says, I can't properly inform myself whether a dismissal is appropriate, I can't properly exercise that decision rationally, because I'm not sure whether these are wild allegations or there's substance to them. If he goes ahead and dismisses, that with respect is not a proper exercise of the power to dismiss in that context, because it is either irrational for substance or maybe attacked for irrationality for process. So for the president to properly exercise that power, he must have all the powers, implied powers that enable him to exercise that power consistently with the Constitution. And that means consistently with the requirement of rationality, the requirement that he can't do so in breach of the Bill of Rights. All of those constrain that power. We're not in a prerogative. My learned friend, Mr. Katz, is 100% correct. We agree with him. This court has said so. This is not a prerogative, it's a power subject to constitutional constraints. And when one reads the reach of that power, one reads it in the context of those constraints. And that is where this power is clearly so implied. It really beggars belief that my learned friend can say, if a minister requests to be placed on special leave for any reason, because the reason doesn't matter, it could be a cancer patient, it could be an accident at work, it could also be like former Minister Kize, that there are serious allegations, please place me on leave so I can pay attention to these allegations and defend myself. Could be just a selfish reason for why he asked to be placed on leave. He says you can do it if he asks, but you can't do it if you offer it to him and he accepts and you place him on leave. That's, with respect, makes no sense. And that is in reality a concession that there is naturally a power that arises from the power to dismiss. And we've argued the power to assign and unassigned powers as well as an additional point.
Just one question from my side, Mr. Maneche. Mr. Mpofu this morning relying on Law Society, and in particular I think paragraph 3 there of to the extent that he argued that public power must not only be exercised within constitutional bounds, but must also be exercised in the best interest of all our people. And he expanded on that principle, and I understood his argument to mean that when one subjects public power to scrutiny, then it would be competent for a court to decide whether the public power is exercised in the best interest of all its people, which would be a standard different from a legality standard or a rationality standard, but almost looking at the merits of the exercise of their power. What do you say to that? Do you accept that that's a legal standard, or would you say that that may be aspirational in terms of the kind of value-laden society in which we live?
Yeah, well, it's not a legal standard. Legality is sourced in the rule of law in Section 1C. We don't know where the public interest is sourced in as a standard. But the public interest criterion, forms part of the president's, could form part of the president's considerations when he makes the judgment call whether he must dismiss or not dismiss, for instance, in the present case. But when he's done so and he's challenged and he says, I did it in the public interest, the rationality standard will ask whether, in fact, there is a rational connection between that reason and what he's done. But it's not the court being invited to assess the exercise of the power and saying, just as a decision, first instance decision maker, is this decision in the public interest? No, that's taking over the power of the president and not assessing it for rationality.
Something that's bothering me, I just need clarity. Minister Mchunu has been placed on special leave. He is still a member of parliament.
Yes.
Still enjoys the benefits. If, I don't know now, the maximum number of members of parliament is supposed to be 400. If that number is 400, inclusive of Minister Mchunu, and the president appoints Professor Cachalia on the 1st of August. Professor Cachalia is supposed to be a member of cabinet and a member of parliament, isn't it? Would he not be in excess?
I'm not sure that he... No, sorry, let me just check that. Because I didn't read the constitution to require him to be a member of parliament also.
For instance, when the late Minister Pravin Gordhan was appointed as a Minister of Finance, he was from outside of Parliament. He became a member of Parliament after his appointment. So why would this be different?
Yes.
So once you're appointed as a minister from outside, you become a member of cabinet, and we know that members of cabinet are members of parliament.
Yes. Can I just, so the section 91(3)(c) says he may select no more than 2 ministers from outside the assembly. And presumably he can appoint me. I'm not a member of any political party. I'm not sure how I would become a member of the National Assembly, but...
He may appoint you, but there must be a vacancy inside the House for you to be a member. Otherwise, there's going to be an excess somewhere, somehow.
Yes, well...
And if Minister Mchunu is still there, then that is the problem.
Let's assume that to be the case. I'm not certain about the legal position, and I don't want... Perhaps my learned friends here will assist me. Let's assume that to be the position. That would not be a national executive problem. It's a parliament issue to resolve. Because it is parliament that decides whether Minister Mchunu must carry on as member of parliament despite the allegations, or what happens to him. That's an issue that is not put squarely at the president's responsibility under Section 91. He appoints from outside Parliament. Presumably, he'll engage his party, and some other person might choose to resign from Parliament. And if we've seen it, especially with this political party.
These people. people doing this. Otherwise, we'll ask you to leave the courtroom.
Yes. What I'm saying, Justice Nhlanhla, is that it would be a parliament issue, but there's probably scope for how political parties resolve this. We've seen parties remove people so that, as Justice Nhlanhla raised with Minister Gordhan, so the space is made for that person to take up their position and then become a minister. There's also a possibility that those instances happen when the president has exhausted the 91(3)(c) situation, because that's limited to 2 ministers. If I recall, the Minister Patel was also a minister appointed under this section. And there are many, truly, these facts are not before the court, so I'm not able to deal with them directly. But what I'm suggesting is it wouldn't impugn the appointment under 91(3)(c), because all that allows the president to do is to appoint from outside. If he hasn't exceeded the maximum, he is entitled to do so. How, after the appointment, and it will be a matter that arises after appointment, not today, as we argue the case, that issue doesn't arise yet. We don't know whether the ANC has its full complement in Parliament or not, and who else might want to step away for Professor Cachalia to take up position. We just don't know. So it wouldn't be a basis on which this court could impugn the appointment of Professor Cachalia. And it's not relied upon by the applicants. Yeah, I know, yes, Justice Nhlanhla, I acknowledge that.
Justice Majid.
Just a quick follow-up. It's not proper for judges to answer questions from other judges, but the way I read it, 91(3)(c) is very specific and must be read with 91(3)(b). See, 91(3)(b) says he may select any number of ministers. And we know there's no cap. There's a complaint the cabinet is too big, but that's another story. Any number of members from the assembly. But the 2 he selects is from outside the assembly, and ergo, they're not going to become members of parliament.
Yes, that was my understanding.
Yes, thank you. So, Mr.
And section 46(1) of the Constitution says...
sorry, which section?
46(1). 46(1) of the Constitution says
Yes.
The National Assembly consists of no fewer than 350 and no more than 400 women and men elected as members in terms of an electoral system. So if you're not elected, you can't become a member. So that would seem to be the answer. Yes, thank you. Thank you. I knew that my resourceful team would come to my rescue.
Mr. Wadan.
I was hoping for a question on the Commission of Inquiry.
Well, there's none.
There's none.
Mr. Madonsela.
Let me just make sure that I don't leave things for Mr. Madonsela here.
Justice Nhlanhla and Justices of the Constitutional Court. Sunday, the 6th of July, 2025, will live in memory as a day like no other day, when the Lieutenant General Mkhwanazi, the whole Provincial Commissioner of KwaZulu-Natal, pulled a surprise move without a warning shot and took to the podium and publicly indulged in a most serious attack not only to the law enforcement agencies, the prosecutorial services, intelligence services, the judiciary, all levers of power in the administration of justice. Of course, the Minister of Police himself was not spared. he was also ambushed with this media conference because he was also in Fryhead attending to his political commitments in the by-elections there. The president, too, the second respondent in this case, was in Brazil. And in the wake of these attacks on the minister and other agencies, and the judiciary in particular, the MK party drew out spears, crying out, "Crucify him, crucify him." That's what they said when the president arrived. They said, "You must dismiss the minister." And in fact, in their founding papers, that's the case they made out. If you look at paragraph 25 or 52 at page 24, and 52.6, saying that the Minister Mkhwanazi should not have been placed on leave, he should have been dismissed. That, in fact, was their demand in a letter of demand at page 44, where they said, with reference to another minister, or the Deputy Minister Whitfield, they said the President should have dismissed Minister Mkhwanazi as he did with the Deputy Minister. So that was the case they made out. In reply, at page 236, paragraph 90, they repeated that claim. They said the minister should have been dismissed. He deserved to be dismissed, as it happened with Whitfield, at paragraph 90 of the replying affidavit. It was in this context that the President, after consultation with the Minister Mkhwanazi, and you'll find this in the answering affidavit at page 172, paragraph 12, where the minister says that I was consulted by the President about this, and he confronted me about the allegations were made by General Mkhwanazi, and I denied wrongful conduct on my part. And that, under those circumstances, the President said, I couldn't resolve the issue. I'll place Minister Mkhwanazi on special leave. May I Justice Theron touch on the point that you raised about what is the nature of this action? Was it leave or suspension? Well, the applicant said in their founding papers, at paragraph 52.1, they said this is just suspension by another name, a fancy name for suspension. And we embrace that characterization. And we embrace it because there is judicial support for the fact that special leave, which is consensual or under the circumstances such as the present, is nothing else but a euphemism for suspension. So when we use the word suspension of the minister, we're using it in the sense that it is a special leave which is a euphemism for suspension. And Minister Mkhwanazi, at paragraph 13 of his answering affidavit at page 173, accepted the decision to be placed on special leave. So it's consensual. So it doesn't matter whether it was requested or granted, but it is mutual between the two of them. So nothing turns on that point. So, my Lord, under this, Justices, under these circumstances then, we seek to engage with two issues only. Whether the President had the power, the ultra-vires argument, had the power to suspend Minister Mkhwanazi. And in this regard, we locate that power. And the second point that we deal with is rationality, but my learned friend has dealt with it. I'll just make a few comments in relation to it. In relation to vires, whether the minister or the President had the power, we rely, as we do in paragraph 25 of the answering affidavit at page 176, locate the power of the President to suspend on section 91(2). And we say that section 91(2) has three components. The first component is that the President can appoint at the beginning, and in the middle, he can assign. If I may pause in the middle for a moment and go to 98 and say, again in the middle, 98 tells us that he can also reassign the functions if the cabinet minister is temporarily out of action or is absent, temporarily absent. And at the end, the third component, he may dismiss. Those are the three parts of 91.2. Now, the argument today is that, well, because those three parts of 91.2 did not contain the word suspend, therefore it cannot be, it's not an express power or it's not implied power. Well, we assume that our premise for the argument is that, yes, there is no express power, but there is an implied power. And we have placed reliance in the judgment of Amapungane in this regard, which is set out at page 50 of our heads of argument. And Justice Konapen, you're right when you referred our learned friend in this regard to the judgment, to the quotation in Baxter in Amapungane, where the court said an implied power can be power that is reasonably required in order to exercise the original power. It can also be an ancillary power. It can also be an incidental power. So when you imply powers, you imply those that are ancillary, incidental, or reasonably required. And that's the quotation from Baxter is set out at page 21 of our heads of argument, paragraph 60. And it's also referenced in Amapungane itself. So we say in this regard that the implied power to dismiss is an ancillary power, to suspend is an ancillary power to dismiss. And in this particular context, it is necessary to preserve the integrity of the investigations which the President has put and set in motion. And the President explains this in the answering affidavit at paragraph 40 at page 85, where he says he wanted to ensure that there is no interference by the Minister on the investigations of the contested allegations that General Mkhwanazi made in that dramatic media conference. So the power, justices, is implied, is there. It is implied, it is necessary and required in order to exercise a determination on whether or not, subject to the outcome of the investigation, Minister Mchunu should be suspended or should be dismissed or should be retained. So that is the necessity of the power. So, my Lord, we say that in support of this implied power, there is both judicial and academic support for the proposition of an implied power. Insofar as judicial support is concerned, we place reliance in the judgment of Mphehle, which is referenced at paragraph 61 of our heads of argument, page 24. It's Mphehle versus the government of the Republic of South Africa. Now, my learned friend says, well, this judgment is not on point for the reasons which I'll deal with in a moment, but here is the reasoning of the judgment. Here is the reasoning of the judgment at page 930 of the judgment itself. Now, this is a case involving the Premier of the Eastern Cape suspending the MEC, and we say that is comparable with the President suspending the Minister, said that the other one is in another sphere of government. In relation to the issue of suspension, the judgment says, judgment of Heath, I agree with the principles referred to by Nhlanhla. Mr. Nhlanhla was then counsel and is now the commission in the Nhlanhla Commission. But then he says, however, the Constitution itself already makes provision for the termination of membership of a member of the Executive Council, which is much more far-reaching than a suspension, and effect must be given to the Constitution as far as the power is concerned. In other words, it says there is power to terminate, but there is no power to suspend. But termination is far more far-reaching than suspension. And then at the end, in the next paragraph, marginal letter D says, on the one hand, a suspension is a well-known interim position or a step or a phase leading to a termination or dismissal, and a suspension in the present instance is clearly a logical and necessary consequence of the powers conferred on the Premier. The logic of the greater, including the lesser, therefore applies. In other words, it says, if you have got the powers that are greater to dismiss or terminate, that includes the power that is far lesser, the power to suspend. There is authority for that proposition. So my learned friend says, well, the problem is that the Constitution as it now stands, it gives it in chapter 5, delineates instances where the power, or the acting powers can, in chapter 5, there will be powers that are acting for acting president as distinguished from the powers, the absence of the powers of the ministers to act. Well, my lord, there is a short answer to that argument. The reason why there is a different section for acting president is that in this country there can only be one president. Not many, unlike the ministers who can be many. But the second distinction is that chapter 5 analogy is unavailing because in chapter 5 you will see when you read the schedule for the oath of office of the president that it is different from the oath of office taken by the ministers. So there has to be a separate system regulating acting president as opposed to a system regulating ministers. So the point is, the chapter 5 argument that there can be nothing in between because chapter 5 separates or provides specifically for acting president and not necessarily for acting ministers is unavailing. So, my lord, apart from the judicial support, there is also academic support for the proposition that the power to suspend a minister is inherent or ancillary to the power to dismiss. You'll find this in Closer, in chapter 18, at page 29, which is referenced paragraph 60 of our heads of argument, where the learned authors of Closer say that the power to suspend is an incident of the power to dismiss. So we both have academic as well as judicial support for the proposition that the power to suspend is there in section 91(2). But there is another reason why the power is there, and it's section 98 of the Constitution, which says that the power to assign functions of one cabinet member to another during the latter's absence is implied by the president. So, Justices, you will see that section 98 says, during the absence of one of the cabinet members, the president may assign a function to another cabinet member. Now, the fact that he can assign in the absence of another cabinet member means that there is implied provision that he can create a vacancy and excuse a minister from being present in order to assign another minister. Especially dealing with a particular scenario where that minister is temporarily absent, not because he is not around or he's been reassigned to another post, simply because he's temporarily absent. So if the power to assign a minister during the temporary absence of another minister is catered for in section 98, that implies that he has the power to create a situation, to allow a minister to be away for purposes of reassignment of another minister. So it is an implied power set out in section 98. So on those two provisions, we say that there is clear authority for the proposition that the power to suspend is implied from both section 98, 91(2), as well as buttressed by section 98, which provides for the power to assign during the temporary absence of a cabinet member. Well, there was some mention in the argument by our little friend, Mr. Mpofu, about the relevance of the Mwabe judgment, that the president publicized in a media statement that he was going to appoint Professor Cachalia. Now, I was part of Mwabe in this court, and Mwabe is no authority for the proposition that a public announcement alone achieves finality in the decision. I know so because if today Cachalia was to approach this court and say to this court, please give me the position that you announced to me because you announced it, he will not get it. That was the result of Mwabe. And finality is achieved, contrary to what Balel friend says. Finality is achieved, and this is set out in paragraph 56 of the judgment, not after public notification, but after personal notification, through a minute by the President, concluded and entered in terms of Section 101 of the Constitution. So Mwabe does not assist them to say that there is a problem with the appointment of Professor Cachalia. There was just a passing comment in relation to Cachalia because that's not my argument. My argument is on there is power to appoint or to suspend a minister. Now, that concludes the argument on ultra vires. On rationality, my little friend has really made the point. I want to make a few points on it. The test is well known in the Mendes Milana case, set out in paragraph 65 of our heads. The question is whether the exercise of a power, that is the power to suspend, is rationally connected with the purpose for which the power was conferred, and the purpose is to assign powers. Now, the justification for the suspension is set out by the President in paragraph 40 to 42, and there are 4 reasons why the President adopted the route of suspension. He says in those paragraphs, 1, it was because of the seriousness of the allegations by Lieutenant Mkhwanazi, whether Mchunu was engaged in criminal activities. That was the first reason. Secondly, the allegations had profound implications for public confidence in the executive. Thirdly, the need for proper investigation into the veracity of the allegations through a Judicial Commission of Inquiry. Fourthly, that the decision to dismiss Minister Mchunu was going to set a bad precedent which would be created if the minister was to be dismissed on mere allegations which can turn out to be unfounded at the end. So these are rational reasons we submit, Justices, which led the President to take the decision to suspend rather than to dismiss. And the context is that he had consulted the Minister of Police, our client, and those allegations about him were denied and had to be investigated, as are the allegations that the Judiciary was also was implicated in cartels, drug cartels, as are the allegations that the law enforcement agencies are infiltrated, and as are the allegations that there is interference by the minister with the workings of the political task team. So the rationality, my lord, the rationality threshold is met in the reasons advanced by the President, and the rationality is not really about the questions which the other applicants are raising, whether it is appropriate to take that decision, whether it's reasonable to take that decision, whether there are other available options, and we have set out why those considerations do not apply here. And if this court is with us on those rationality arguments, and therefore the application should be dismissed.
Mr. Matunsela, any questions? Looks like there are no questions for you, Mr. Matunsela. Thank you. I think you should run before colleagues change their mind. Tempofu?
Leave of absence. Thank you, Justices. Maybe let me, well, first, the deal that we discussed with Mr. Katz is on.
The 5 minutes,
No, all of it, the 10.
whole.
10 past 10.
So it's 20 minutes.
Yes. Thank you.
You confirm that, Mr. Katz? Thank you. 20 minutes.
Thank you. So, okay, so I'm going to make sure I've got, let me take off my watch. Oh, there you go. Thanks. Yeah. So that at least by the time that 20 minutes elapses, I must have said everything I want to say. Let me do this, Justices. I'm going to resist the temptation to start with the point that was donated by Mr. Madonsela based on Mngcwabe, tempting as it might be, because I want to approach my argument differently this time in reply. We, and when I say we, I mean respectfully, I'm including the court, discussed in detail the issue of implied power, and virus and all that. But in my respectful submission, we did not deal with the rationality issue sufficiently. So with the leave of the court, I'll start with rationality this time, so that even if I run out of time, then on implied powers and virus, then and at the back of what I'm going to say, also which might also save us time if we do reach the issue of implied power, is what I said in response to Justice Rogers, which is that there's a clear overlap between the so-called necessity test and the rationality test in the manner that I've explained. So let's go to rationality. And as I say, whenever I deal with this, let's also keep in mind this question of necessity. So what do we have here? Mr. Manager is really telling us this, that the decision to place on leave of absence is rational or rationally connected and linked to the stated purpose. Remember, what is the stated purpose? The generous one that I'm going to grant them. The stated purpose is that this is leave of absence, suspension, call it whatever, pending the outcome of the commission. Right? Now, I'm going to demonstrate the fallacy of that argument, to show that there is no rational connection conceivable between the leave of absence and the outcome of the commission. We have evidence, live evidence, that this president will, irrespective of the outcome of a commission, will not only appoint you to be a minister, but actually promote you if there's an opportunity for doing so. Let me explain. Because for that argument to hold, it must be that really the president is saying, I don't know about these allegations. I must await the Nhlanhla Commission. If it says there's prima facie evidence, then I may dismiss. We must believe that story. Well, that story, there's no South African, nobody who lives in this country who can believe that story. No one. Because and the president says the reason why I'm taking all the steps is because the allegations are untested. So they'll be tested where? In the Nhlanhla Commission. But that is a fallacy. Because when the allegations against certain ministers were tested, and this is in our replying papers, those allegations were now tested in the Zondo Commission. And those ministers were said to be prima facie criminally liable. The thing that he says he's waiting for in relation to Minister Mchunu, when that happened, the president appointed those people to be cabinet ministers. And the live example of that is none other than Minister Gwede Mantashe. Let's call it the Mantashe test. The president, to sustain that argument, would have to pass the Mantashe test. And he fails it dismally. Because, as we speak now, today, despite the tested allegations that were in the Zondo Commission, what did the president do? He has appointed Minister Mantashe as acting Minister of Police now, today, as we speak. What does that mean? It means if Minister Mchunu were to be placed in the same position as Minister Mantashe in 3 years' time, after the Nhlanhla Commission finishes its work and the review applications and the appeals and all that happens, then we would have, let's assume then the Nhlanhla Commission says Minister Mchunu is prima facie criminality and so on. So he would be in the exact same position as Minister Mantashe now. And we have had evidence that that would mean he would be qualified. In fact, not only has Minister Mantashe been appointed as Minister of Minerals and Energy, and now appointed as acting Minister of Police, he has even been promoted to acting president recently. So if you do wrong and you are found by a commission to have possible criminal liability, not only are you not going to be punished, but you are going to be promoted, probably. What is that? We cannot, this president, I know he can do no wrong, is the super saint. But there has to come a time in this country where we must say, this far and no more. You cannot have a president who's going to come to this court and say, in open court, daylight, I am waiting for these things to be tested so that I can possibly dismiss. When all the evidence shows that with Minister Mantashe, with Zizi Kodwa, with Deputy Minister Mahlobo, all the people who were implicated in the Zondo Commission have been appointed by him. Now, he says the allegations are untested. Well, all of us would love to be in this university where you can't fail. You can't fail the test. Because the more you fail the test, the more you're going to graduate. And we call that rationale? That we are all, the whole country must wait for 3 years and spend 2 billion rand to get to a stage where nothing is going to be done. Or if something is going to be done, it's probably going to be a promotion of Minister Mchunu. That is the reality. That is how we must approach the rationality test in this case. Now, once you remove the facade of the artificial connection between the outcomes of the Nhlanhla Commission and the so-called leave of absence, then its rationality goes to the dustbin. It is simply an excuse to make sure that Minister Mchunu continues to have his salary. Mr. Katz put it properly. The only purpose, I'm inviting anybody to think of any other purpose that is going to be served by the leave of absence, apart from making sure that Minister Mchunu retains his salary. What is it? There isn't. And that can never be a rational purpose for exercising presidential powers in any country. Now, Mr. Manager tells us about, he dealt with the rationality. I think one of the justices asked the question about the dismissal or non-dismissal. Let me put it like this. We all accept, just so that I'm not misunderstood, we all accept that generally speaking, the rationality test is not what one of the parties, I can't remember which one, accused us wrongly. It's not a whataboutism. So you don't say, okay, well, I suspect it was Mr. Madonsela. You don't say that, well, you placed him on leave. Why did you not dismiss him? In general, you don't do that because it has been said many times in pharmaceuticals, in Albert, in all the cases. But this is not, when we talk about the dismissal of Minister Mchunu in this particular case on these facts, it's not in that mold. Their own version is that this power to place on leave of absence is derived from the power to dismiss. Right? That therefore means on their formulation, you can never take the decision to give leave of absence without having first considered the decision to dismiss and discarded it. So it's not the whataboutism mold. It is to say, because you are saying that power is, someone was even saying a lesser power or whatever. But its parentage, its ancestry is the power to dismiss. So before you do leave of absence, you must have at least taken a decision to retain or a decision not to dismiss. And it is in that context that we say that prior decision, it's about the breaking of the egg and the omelette. That prior decision not to dismiss was in its own right irrational as well. But if its corollary, to quote my learned friend, is to retain. The president would have been within his right, by the way, and I said this earlier in my address, to retain, to say, after the discussion apparently, to say, yeah, okay, from what you're saying, I'm keeping the minister and I'll wait for the outcome. And if he's found to have done something wrong, I'll dismiss him or whatever. He could do that. That would have been irrational. It would have been not a nice decision. Many people would be aggrieved. But on the rationality test, he would be prepared to do it. Now we're told by the president that there's no such thing as the prerogative. Latching on Mr. Katz's, shall we say, overstatement. I'm trying to, because he's on my side, to make sure that I don't. We know this thing about the prerogative is actually very simple. Hugo gets abused, and I probably am guilty of this as well in other instances. Hugo simply says that we don't have the royal prerogative. Everyone knows that. But we have what is called, what I call, it's actually my own term, yeah. I call it the qualified prerogative. In other words, you still have to pass the rationality test. But there are powers that are the sole preserve of the president. But what is really said is the president who can speak with both sides of his mouth and comes here via his counsel to say there's no such thing as a prerogative. But if you go to page 159, that's annexure, annexure AAA5. You hear, it says, the heading, statement by President Cyril Ramaphosa on the removal of Deputy Minister Whitfield. So this is his own statement, the same as when his counsel speaks for him. It says at paragraph 160, after he criticizes, well, first of all, he starts with in this court he makes the false statement that Mr. Whitfield admitted his transgression. That's false. There's no nice way of putting it. Because in his own statement, he says Mr. Whitfield and Mr. Steenhuisen were distorting the facts and what have you. So if they admitted guilt, what is it that they were distorting? But that's not even the point. The point is that he says at paragraph 1234 on page 60, given all these circumstances, there is consequently no reasonable grounds for Mr. Steenhuisen and the Democratic Alliance to issue ultimatums and threats when the President exercises his constitutional prerogative and responsibility. This is the person an hour ago who said there's no prerogative. And then further down, it says, it is unprecedented, this is now President Ramaphosa speaking, it is unprecedented in the history of our democracy that the exercise by the President of his constitutional prerogative and responsibility with respect to a clear violation of the rules and so on and so on. So when it suits the President, there is a prerogative. When the shoe pinches, there's no such thing. And just for the sake of completion, page 259, there's an interview done by the spokesperson of President, who was in the position of Mr. Manecha, also speaking for the President. He says at 259, he's asked by Ms. Naledi Moleo of Newsroom. I think the big question is what do you call the straw broke the camel's back? Was it Friday when the minister filling out account before the portfolio committee and so on? It says, well, the people can opine, and when the president can exercise his prerogative, and when can the president exercise his decision. But I think a couple of factors, and further down says the second thing, even in the exercise of the prerogative, anyway, the point is made. The point is simply that everyone knows that when we say the prerogative, and to the credit at least of the president, we all know that means what I call the qualified one, where rationality is at play. But now those statements are being disowned. Now, if there's one thing I have to say is this: the use of the word dismiss in this context, not the use, because it is what it is in the Constitution, but the flawed understanding of that word dismiss is what is really at the center of this case. Because everybody, all of us as lawyers, I suppose, instinctively, when we talk about dismiss, we think about the dismissal of an employee, dismissal of a school principal, and so on. But this is not a dismissal of that kind. This is a removal. This is a withdrawal of someone from the cabinet. And that is why the section on this, section 192 I'm sorry, so section 92 that we all been talking about, 91(3)(c), sorry, uses the word select. Right? So, the power to appoint, obviously, that's the formality. But this language is used advisedly. 91(3), the president must select the deputy president. The president may select any number of ministers, and the president may select no more than 2 ministers from outside the assembly. So what is happening when you, quote-unquote, dismiss a minister is not all these big things about you must prove a case and what if they... It's just a simple matter of deselecting. You are simply deselecting that person. You are not punishing them. You are not impeaching them. You are not doing anything. Just as when you select them, they don't say, well, there should have been an advert in the newspaper, and there should have been a shortlisting and an interview. No, you select them. And just as you must select them easily without having the formalities of employment, you may equally deselect them. And that, yes. So that is those are the points that I want to make without interruption.
So that's it, Mr. Mpofu.
Well,
unless there are questions. Unless there are questions,
yes.
Mr. Mpofu.
Well, I wanted to deal with the question of the commission, but just because my learned friends were asked on it, but it's fine. I'll
hope if you can only hope if there are questions, hopefully you can respond. But doesn't look like there are any. So that will be the end of the matter. Thank you, Mr. Mpofu.
Going.
Going, Mr. Mpofu.
Going. Well, thank you, Justices. No, I know that I speak for all my learned friends when we are saying we are indebted to the court. And we also understand that we all have to be somewhere else just now. And therefore, any of the issues that I did not deal with in reply were covered in our heads, as the court pleases. We're indebted to the court.
Thank you very much. Thank you to the colleagues. We need to consider this matter. We are aware of the time constraints. We are going to reserve our decision. I'm saying decision. And we are going to notify the parties as soon as possible as to whatever decision that we are going to take. Yes. But it's not going to be today. We can't do it now.
Justice, we understand, Justice Nhlanhla. If you just give me half a second. I can't remember what prayer it is, but in the notice of motion, we've catered, we do understand the matter is quite complex. So we made provisions for a situation where the court might reserve judgment. And I won't take it further than what is stated in the notice of motion and in the founding affidavit as to what interim measures could be taken. I'll just leave it in the hands of the court.
Reserves its decision. Court adjourns.
As court please.
You can't reply on the commission. They refuse to ask the questions.